Good morning, good afternoon, good evening to everybody joining us in this virtual hybrid event. We welcome you to the first International Academy of Comparative Law Congress on African soil and also to the first hybrid one. We are honored to co-host this Congress with the Academy of Comparative Law with the Faculty of Law at the University of Pretoria during the Southern Spring. And spring has sprung, as you would have seen while you were driving here. All the jacarandas are in full bloom. During the last 20 months, the COVID-19 pandemic has disrupted our lives, also the hosting of this Congress. Initially scheduled for 2020, it was postponed, and we feel truly blessed that we are now in a position to host it in a hybrid format. The theme of this Congress is Plurality and Diversity in Law. It was appropriate when it was first mooted, but it is even more appropriate now. The pandemic has placed this in a completely new perspective. The world has been forced to work together in order to manage and eventually conquer the pandemic. No country can be left behind. Similarly, the plurality and diversity in legal systems around the world is the source of our comparative efforts and applications. This rich source of materials, practices, and experiences must also be brought together in a way that makes sense in an increasingly globalized world. No country is an island any longer, and no country may be left behind. The discipline of comparative law enables us to exploit diversity to the full and to create a better world for all. In this era of disruption, but also reimagination, we are called upon to take the lead and to inspire young and upcoming academics and lawyers to join us, also in reimagining our discipline and how we practice it with so many new virtual opportunities available. May this Congress be the start of many more and also more inclusive academic engagements, making full use of the technological potential that we have uncovered during this pandemic. Our lives have been disrupted, but we have never been better connected. A very warm welcome to everybody. I will now hand over to the President of the International Academy of Comparative Law, Professor Katharina Boele-Woelki, to do her welcome as well as the introduction of the keynote speaker. Thank you.
Conférence thématique de l'Académie internationale de droit comparé sur la pluralité et la diversité en droit. Je vous salue tout très chaleureusement, de près ou de loin. Welcome, bienvenue à la première conférence de l'Académie depuis son existence en Afrique. Je suis extrêmement fier que l'Académie se réunisse enfin sur ce continent du monde. Bienvenue à la conférence ici, dans la belle Afrique du Sud, que l'Académie a dû non seulement reporter pour la première fois en raison des circonstances connues, mais qui a également été préparée avec une pré-conférence en ligne qui a eu lieu il y a exactement un an. Bienvenue à la première conférence hybride de l'Académie avec des personnes réunies en présence et environ 200 personnes qui participent en ligne. Many years ago, when we made the plan to organize a conference of the Academy in Africa, I did not imagine that we would not exchange ideas with hundreds of experts in comparative law here together on the ground. Due to technical advancement, we were able to organize a pre-conference which took place online exactly 1 year ago. However, it could not replace our demand for networking and exchange. We are extremely grateful for the opportunities provided by the University of Pretoria, that despite the adverse circumstances that keep us on our toes around the world, we can have this conference finally to take place. I would like to cordially thank especially Elsabe Schoeman, Dean of the Faculty of Law of the University of Pretoria, and her team for their flexibility, drive, helpfulness, and hospitality. You are our dream team. I would also like to extend a big thank you to our Deputy Secretary General, Alexander Senegachnik, who is an excellent communicator and a problem solver, whatever occurs. He has been highly instrumental in co-organizing this event. In addition, he designed the wonderful program cover with a giraffe, which perhaps hangs its head not only because of its length, but also because we cannot be all united here in Pretoria. And finally, another big thank you to my friend Diego Fernandez Arrojo, the Secretary General of the Academy, who is always available. Again, our cooperation has been constructive, effective, and very pleasant. Plurality and diversity in law is the general theme of this conference. Diversity refers to differences and commonalities of people or groups. These can be considered on an individual, institutional, and structural level and affect all people, not just individual groups. Whereas plurality in law, or better legal pluralism, stands for the existence of multiple legal systems within one human population and or geographic area. South Africa is a very good example for this. Both meanings will be explored and exemplified at this conference from a comparative perspective. Undoubtedly, the recognition of plurality and diversity in law is imperative for respectful comparisons of legal systems at all stages of the comparative process. In identifying similarities and differences, we recognize that there are multiple solutions and approaches to factual problems, even as already indicated within one jurisdiction. However, there is a need to differentiate. The comparison should detect nuances and variations. If the legal systems on the one hand, and within legal systems, different regimes on the other, if they are to be classified into boxes of a table with yes and no, this is not sufficient. It is important to distinguish between the various levels of similarities, almost the same, alike, related, comparable, parallel, analogous, akin, and differences, dissimilar, unlike, unrelated, disparate, contradictory, conflicting, incompatible, and irreconcilable. Chers amis du droit comparé du monde entier, les thèmes de cette conférence sont tous extrêmement actuels. D'excellents rapports ont été préparés. Restez avec nous aujourd'hui et demain. Nous vous proposons une variété de sujets et des formats différents, à commencer par la leçon inaugurale qui sera donnée par l'ancien juge Edwin Cameron de la Cour constitutionnelle sud-africaine qui est bien connu au-delà de l'Afrique. Je ne m'étendrai pas sur son impressionnant CV, car les bibliographies de tous les intervenants dans ce congrès se trouvent sur le site web du congrès. Nous sommes extrêmement fiers que Edwin Cameron nous fasse l'honneur de partager avec nous son point de vue sur la pluralité et la diversité dans la notion de droit sexuel. dear friends of comparative law around the world, let me greet you all from far and wide. The themes of this conference are all extremely topical, and excellent reports have been prepared. Please stay with us today and tomorrow. We have on offer a variety of different topics and formats, to begin with the opening lecture, which will be delivered by former Justice Edwin Cameron of the South African Constitutional Court, who is known far beyond Africa. I will not elaborate on his impressive CV, because the biographies of all speakers can be found on the Congress website. We are extremely proud that Edwin Cameron does us the honor of sharing with us his views on the plurality and diversity in the notion of sexual rights. And before I shall give the optimistic, and I'm confident that by then it will be possible for all of us to meet there again in person. I wish us all a fruitful, inspiring conference and stimulating discussions, and thank you for coming to Pretoria, and thank you for being connected with us online. Thank you very much, and I would like to ask Edwin Cameron to come here and deliver his inaugural speech.
Chers amis, chers participants, chère la professeure Katharina, that's the extent of my French. I'm delighted to be with you here this morning. Ek is verheug om saam met u op hierdie campus te wees. Ngiyajabulo ukukubona zonke. I'm happy to be with you. Good morning, ladies and gentlemen. That's better. In Africa, we respond. So those of you online, please, if we can see your faces, just wave. Good morning, ladies and gentlemen. Sanbonani, Dumelang, Ndimasiari. I'm really pleased to be here. And I want to say how happy I am that you have selected the University of Pretoria for your venue of this conference of comparative and international law, international comparative law. The University of Pretoria, in the late years of the 1980s, when the apartheid government was cracking down on opponents, and it looked very dismal for whether we'd be able to have a transition at all, let alone a peaceful transition, founded the Center for Human Rights. And it was capably led through our transition by persons within the university. Very tragically, on the 28th of March this year, one of the leaders of the Center for Human Rights at this university's law faculty, Professor Christoph Haynes, tragically and prematurely died at the age of 62. I pay tribute to him for his role. And in speaking of the Center for Human Rights, he told me a funny story, Christoph, about one of my distinguished older colleagues on the Constitutional Court who was asked to come to this university, to this venue in this lovely law school, and to give a named lecture on a specified topic. And my colleague arrived and he got up and he said, I've been asked to speak on this topic, but I'm not going to. I'm going to speak about my own experiences. I'm not going to do that, but it was a funny story, especially if you know the colleague, and some of you here might know it. But let me take time, a la the colleague, to say a few things about our country before I get to my talk. And it's this: like Hungary, like Poland, like Belarus, Burma, Rwanda, like Peru and Ecuador, like the United States, where a far right, hard right, ideologically rigid majority now threatens the rule of law and legal rationality in one of the first major constitutional states of the world, America. Like all of those jurisdictions, we're in trouble. We're in a perilous state of our country. We suffered a severe insurrection at the hands of the supporters of a former president who was jailed by the Constitutional Court in an extraordinarily courageous judgment by Justice Sisi Kampepe, a beloved colleague of mine. The majority of the court reinforced that judgment only a week or two ago. That insurrection, attempted putsch, is a moment of peril for our country. But I want to assure you not just that we are like other places where the rule of law is in peril and under threat. I want to give you some facts. First of all, our Constitution is rightly debated. There are, from the left and the right within this law faculty, there are attacks on its values and attacks on its exponents. Those are welcome. But despite that, within this Constitution for 27 years, 27 and a half years, we have had a functioning democracy, an imperfect democracy, a far from ideal democracy, but a functioning democracy. We have, without doubt, one of the world's most outspokenly jubilant, joyous, free media. Things are said in our media which would land people in prison across the border in Botswana or Lesotho or Eswatini, in Zimbabwe, and we have a free media. More than that, we have strong institutions, both in civil society and in Chapter 9, perhaps not as strong as we want them, but institutions that are clamant in their demand that we remain an accountable, transparent democracy that answers to the needs of our people. One of our biggest failings, one of my biggest failings, I sat in the Constitutional Court for 11 years, and the political elite has failed the dispossessed and the marginalized in South Africa over the last 27 years. We have not done enough to realize the rights that are afforded in our Constitution. Let me recognize that, and let me recognize my part in it as a judicial officer in our Constitution since 1994. Nevertheless, our civil society institutions are clamant, they're powerful. There's nothing to compare with them in the rest of Africa, and I would say in most of the middle income and developing world. Particularly important are civil society institutions like the Center for Human Rights, like Section 27, like the Center for Child Law. Dean Schoeman, you must be very proud of Ms. Oza and Professor Anne Skelton, who have done pioneering work for children's rights in a difficult. My own old home at the University of the Witwatersrand Center for Applied Legal Studies, Section 27, the former AIDS law project. Very, very powerful institutions which claim the space and demand accountability. Freedom under law, CASAC, the Council for the Advancement of the South African Constitution, many other organizations that I could mention to you. But most important, we have got a skeptical population. It's a population that learnt under apartheid that governmental power can and must be challenged. The pivotal moment in the end of apartheid wasn't the entry of the ANC. Am I saying something controversial, ladies and gentlemen? The ANC didn't come in on a ship from Mars and rescue us. 4th of December, 1984. The Mass Uprising, 8 years after the Soweto Uprising, in the Vaal townships, 70 kilometers from where we now are. That signaled the beginning of the end of apartheid. The result is that the students that you'll meet, and I hope you will meet students, are deeply critical. They'll say, what did Justice Cameron say to you? And they'll be maybe even denigratory. I welcome that. We have a population that is not submissive, that will not bow its head to humbug and to dictators. And we were in danger under the former president of bowing our heads to humbug and lies, Trumpite lies, and insurrection recently. So all of that in deviation, Professor Katharina, from my speech, a bit like my previous colleague. Professor Schoeman, would you like me to go on for the next 40 minutes, or shall I revert to my speech? I'm embarrassing Professor Elsabe. So I welcome you, and I'm proud that we have a thriving legal culture in this law school, in all law schools, the law clinics. You have a law clinic here as well. We have one at Wits, we have one at Stellenbosch, where I'm Chancellor of the university. So I'm proud to say to you that we are in peril. We have got a fight on our hands, those of us who believe in social justice, in redistributive policies, in protecting the marginalized and the poor. We have got a real fight on our hands, but it's a fight worth fighting. And it's one that I encourage all of us to participate in. And it's one that I commend the IACL for selecting this city, this university, and this jurisdiction for its conference. Comparative law has played a vital role in shaping our law in this country. Our Constitutional Court has acknowledged that other legal systems may enlighten us in analyzing our own law and also assist us in developing it. And that is why our Constitution contains an express provision inviting courts and requiring them in certain circumstances to look at foreign jurisdictions. And in particular, Professor Katharina, to come to my theme today, comparative law has played a very important role in the development of LGBTIQ rights, which I refer to as queer rights. And I appropriate the term queer because I grew up, my last 4 years of school were just across the road, a lovely school, whites only. I was a poor kid. My big break came 500 meters from here at this lovely school. If you get a chance, walk across the road and go and look. It's on a hill. It's the same architect as did the Union buildings, and it looks across the valley of Pretoria to the Union buildings, built at about the same time. That school was homophobic, like so much of the rest of Africa still is. And I felt a wince in my adolescent being every time someone said queer. Now I say I'm proudly queer. I'm proud of myself to be Stabane. That is an equally opprobrious term in the Nguni languages for a queer person. We appropriate these terms because we will not look back in shame. We assert ourselves in pride. And these rights in our Constitution have not been gifted by the global North, by France or Europe or North America to the global South. On the contrary, the global South has helped to trailblaze LGBTIQ rights in taking the greatest steps to empower queer communities and to repeal colonial era anti-homosexuality laws. We became the first country anywhere in the world in 1994 to enshrine sexual orientation as a protected condition in our Constitution. I'm going to tell you a little bit later about how we got there. Well, while law reform is necessary for social change, is it sufficient? The answer is no. Through most of legal history, it can fairly be said that the law was used to enforce and reinforce class privilege and racial and gender hierarchies. Males, white males like me, we wrote the history, we wrote the laws, we told what you could believe and what you could not believe. We attributed doubt and dubiety to other value systems. But in Africa today, and democratic South Africa in particular, the role of the law is diverse and inclusive, and it gives voices like the voice of Justice Sisi Kampepe. I'm so proud of her. She is a woman in the strongest traditions of our continent in writing those two judgments in the final months of her tenure on the Constitutional Court. But Professor Katharina, Professor Alexandre, I want to take a step back and ask, why is this queer thing so difficult? And there are a number of good reasons. The first is that it concerns sex and intimacy. When I spoke about my adolescence, I told you a shocking thing. that as a young adolescent, slightly late at the age of 14, wasn't 11 or 12 or 13, to discover to my utter horror that I was emotionally and sexually attracted to other men. That's a very intimate thing to say to you. So it concerns an intimate aspect of my functioning as a human being. The same if I were transgender or lesbian. And then, of course, it's about sex roles, man and women. One of the things that we deal with as queer people is people's prurient sense of inquiry. What do you do? Especially women get this. Are there any queer women here? Maybe online, I'm sure you are, but you get the question, either from relatives or from friends. I see you smiling. I'm very glad you smile because it's true. And I hope to give you lots more reason to smile in the course of the next 20 or 30 minutes. Women get, what do you do? Who does what? It concerns sexual roles, men and women. Then, of course, we've got patriarchy. Don't tell me it's an African problem. Look at Lukashenko. He's a white European. He's the worst patriarch in the whole of Europe. And next to him is an even worse patriarch, Putin. But it's a problem in Africa like it is somewhere else, where women are expected to be subordinate. They are expected to be available for sexual utility. And that is a problem worldwide. And then especially in Anglophone Africa, worse than in Francophone or, does I say, Lusitophone, Portuguese, East and West Africa. We've got the problem of the colonial laws. They imported homophobia into Africa. It wasn't an idyll. There's been a very good article written. Those of you online, if you Google Marty Media and Giuseppe, it's a young man, Raj Kumar. He's a young Stellenbosch student who's written a wonderful article, appeared yesterday, on colonial era repression of homosexuality. Not an idyll, but there were transgender traditional healers. There were lesbian sangomas. There were same-sex people. There were queer men living peacefully in African communities across the continent until the white settlers arrived. My mother's great-great-great-grandfather was a Schoeman. We are related, Elsabe. Yeah, 1704. Did you know that? It's in my uncle's book, Die Laaste Boek in Afrikaans, Karel Schoeman. And 1704, the first Schoeman comes here. He brought queerness with him. What rubbish. Queerness was always in Africa, everywhere in the world. 7 to 10% of us are queer. So the other reason, and I'm still going through the reasons why this is so difficult, is the pernicious misconceptions about us. It's not chosen. I promise you, from the bottom of my heart, when I was 14, if I could have chosen, I would have chosen heteronormative, masculine, patriarchal heteronormativity any day. I am queer today because I have no choice about it. Secondly, it's not contagious. It's not acquired. It cannot be passed on. Conversion therapy is rightly being criminalized. We will get there because our parliament, our public discourse is extremely progressive on queerness. And I honor, I didn't mention that at the beginning, but you say an anti-queer word in South Africa as a politician at whatever level, you'll be jumped upon. From 2006, when aspirant President Zuma then said a homophobic thing and he was disavowed by his own supporters, he had to apologize, and he did apologize. He's the only African head of state in history who has apologized for homophobia. So we are a natural variant across all societies, like left-handedness. Who's left-handed? Please put up your hands this time. I'm not asking if you're in a same-sex woman's relationship. There must be someone who's left-handed. Who's left-handed? Marcia, I see links. Nee. Someone's putting up their hand. It's about 7% of the world, and the same is true of sexual orientation and gender diversity. But the big difference, of course, is that we are mute. We are invisible. I speak out because it's so important to speak out. But across Africa, across Eastern Europe, the Middle East, North Africa, Muslim societies, China, it's still silent and mostly invisible. It's very difficult to know who are queer and not queer. So let me get back to what I promised you, Professor Katharina, which was how we got 1994. And it's an exciting story. A young man in Sebokeng, which is a very poor township that I mentioned in the Vaal, next to Sharpeville, where one of the first massacres of the apartheid government occurred in 1960, on the 18th of March, 1960. Simon grows up, he joins the anti-apartheid struggle because he's poor, because he's black, because he's politically conscious of the gross injustices of apartheid. And he's also queer. And it's not but he's also queer, it's and he's also queer. He becomes a leader in Sebokeng. This mass uprising takes place, a terrible event on Monday, the 4th of September. Let us not disregard the violence and cruelty that occurred in our pursuit of democracy in our country. Let us understand it in the richness of history, but let us not disregard it. Simon is arrested for murder, for treason. He's accused number 13 in a famous trial with a number of the internal leaders called the Delmas trial. And Simon does an astonishing thing. 1985, he does an extraordinary thing. He comes out to them. He says, I'm gay. And what do? Terra Lakota, Popo Molefe, Mos Chikani. They say, no, we reject you. Go away. Go to a separate cell. We will not have you dishing our food. We will not put you on our roster for dishing food. What did Simon do? Did he slink away? No. He said, how dare you? You don't have more right to claim anti-apartheid credentials than I have. I've put my life on the line. I'm not a leader in one of the anti-apartheid organizations like you leaders are. I'm a poor kid from Sebokeng, and I refuse to separate my blackness, my anti-apartheid activism, my poverty from my queerness. Simon made it possible. Later on, I've always been a white man in a suit. I didn't come here dressed in drag, Professor Katharina. I've been too cowardly all my life, and I don't know if I'll ever gain the... I'm glad you're smiling, Professor Schoeman. I'm so pleased. So the white men in suits, including me, managed to persuade the constitutional negotiators to include sexual orientation. We could not have done it without the moral authority that Simon, Tseko, and Kodi from Sebokeng gave to us. So after the inclusion, it's been a tough struggle on race and class grounds. If you're a white male homosexual like me, living in the northern suburbs of Johannesburg, as I'm privileged to do, you're safe. If you're a black lesbian in a township, you are in peril. It's happening. It's still happening in the recent past, especially effeminate presenting queer men and butch presenting lesbian women are a terrible risk in our townships. But the rich constitutional protections have had a significant impact. I'm not going to go through all my notes here. I just want to tell you one thing that's really fascinating. There's a foundation called the Other Foundation that commissioned a nationwide survey. It came after the Pew Research Institute, which I think you know of. It's an American, North American-based institute that does very interesting research on various issues. They came to South Africa about 10 years ago. I think it was a bit less than 10 years ago, 5 or 6 years ago. And they asked a difficult question. They said, should society accept homosexuality? And throughout Africa, 1 or 2% said yes. South Africa, they said 32% yes. It was a difficult question. It didn't say, should we tolerate, or should we condone, or should we, it said, should we accept? 32%. I thought it was remarkable because outside North America, Western Europe, and Australasia, and some countries of South America, the results were all below 5%. South Africa, 32%. It's got better. Let me tell you the good news, and I'm proud to tell you this morning. The Other Foundation survey says, do you regard homosexuality as immoral? 72% of South Africans, black and white, urban and rural, township, suburbs? Say yes. Next question, should LGBTIQ, queer South Africans, retain constitutional protection? 52% say yes. You can walk on the streets of Soweto and you can know that the pathologies of lesbian violence are confined to the pathologies of gender-based violence, of sexual and gender-based violence against women. They're not mainstream. The majority of people in Soweto, the majority of people in our suburbs and rural areas say that we should retain constitution. It's a complex answer because it shows the constitutional sophistication of our people, that you are willing to say it's immoral, and yet you recognize people's entitlement to protection. Let me skip some of this. I want to mention a beautiful lesbian, Judy Simelani, who was a wonderful soccer player, and she was on the East Rand when she was murdered some years ago. I just mentioned these. Anele Bengu in Kwamakuta Township this year in KwaZulu-Natal, murdered. These tragedies reveal the bravery, they reveal the courage and the cost of coming out in class and locational circumstances, namely townships, where you put yourself at risk. They underscore the need for us to take that 52% of the other foundation survey, to take it to 80%, and I believe we are going to get there. I'm just checking what I'm still going to tell you, Professor. I'm going to get back. When we discuss plurality and diversity in law, we need to change to go beyond the conferences and statute books. We need to explore tangible change on the ground, change in the courtroom, change in the workplace, change in communities and families, and to ensure that the law triggers and encourages a shift in those deeply embedded societal norms that regard gender diverse people and women. That's what I have in common in all my whiteness and maleness and privilege with women who suffer gender-based violence, that I understand just a bit of it, just that little pinky tip of my finger. I'm not claiming to understand it, but I understand the patriarchal heteronormative subordination that thinks they're entitled to abuse women because LGBTI people, queer people like myself, are also abused in that way. So across most of Africa, for most LGBTIQ people, the risks of self-identification remain perilously high. As of December 2020, 9 months ago, same-sex love remains illegal in 31 of the 54 countries of Africa. It is punishable by death in Mauritania, Somalia, and in parts of northern Nigeria. It is punishable by 10 years or more imprisonment in Tanzania, Kenya, Zambia, Malawi, and elsewhere. It is punishable by 8 years imprisonment in Ghana and Ethiopia. In Ghana right now, and I'm deviating from my notes, I think I've got notes on that a bit later, but let me tell you now. In 2014, Nigeria brought into law a 2013 statute called the Same-Sex Marriage Statute, which until this year, until 3 months ago, I described as the most homophobic statute ever put in writing by any human community. Where are the observant Catholics and Muslims and Jews? I like to taunt monotheists. Anyone mind if I make a comment about monotheism? Jy mag nie glimlag nie, jy moet oppas vir my Elsabe. Excuse, yeah. So more than any Talmudic supposed prohibitions, the Nigerian law was hateful and oppressive. If I landed in Lagos and said there should be equality for LGBTI people, I could be arrested for propagating, just with that statement, propagating same-sex marriage. And of course they're right. They're right to say that LGBTIQ people should have equality and justice and peace and safety and security. In a way, the logical end point is that you will grant them full moral citizenship as we did in South Africa in 2005 with the Constitutional Court decision, in 2006 with the act that enabled same-sex marriages in South Africa. So they're right, but it's a vicious act, because you, in saying that you want equality for LGBTI people, you aren't committing yourself to propagating same-sex marriage. You might disagree with it. You might have conscientious objections, or you might have objections to marriage as a subordinative patriarchal institution. So it's not logically connected, but except in the implicit sense that I've said. The Ghana law is far worse. To my relief, I want to tell you, and this is where comparative law is important, Professor Katharina. Prominent Ghanaian lawyers have spoken out. I'm so proud of them. I asked Ghanaian activists at a Pan-African ILGA, International Lesbian and Gay Association conference on Constitutional Hill 2 months ago. I said to them, who are the Ghanaian lawyers who are partners in international firms in Paris, in London, in Sydney, in Atlanta? Those firms don't countenance homophobia. Have you asked them, have they taken a stand? I said to them, what about the accountants who are partners in Ernst & Young and Accenture? The prominent leaders of Ghanaian society in Accra and other cities. Have you challenged them? I'm very pleased to say that there's been a statement just a few days ago, a beautifully, deeply principled, thoughtful statement that you can get on the web that condemns this legislation. Let us hope that Ghana, which has a rightful pride in the depth of its culture, going back centuries before the white people arrived in the west of Africa, let us hope that that Black African dignity extends to all Ghanaians, including queer Ghanaians. But that kind of hateful persecution exists in Zambia. I don't know whether the new president takes a different attitude. His predecessor, President Lungu, had a very queer, if I might say so, obsession with queerness. Why? Like President Magufuli before his death in 2019. What's it about us? Why are you so intrigued? Why are you so obsessed? Leave us alone. 2 men booked a room at the end of 2019. I want to honor them with their names, Japhet Chataba and Stephen Samba. And they locked the door, they went inside the room, and one of the hotel staff peeped through a curtain and called the other hotel staff. They were sentenced to 14 years imprisonment in Zambia. They've been released. Cameroon, 2 transgender women, Shakiro and Patricia. Let me honor them with their names. Loic Njoikam and Roland Moote. They were imprisoned for attempted homosexuality, for being transgender people, genitally male. What a grotesque thing for me to have to say this, Professor Katharina. Genitally male, but in every other respect, identifying as female, attempted homosexuality. What is it on our continent? This belongs to Belarus and Hungary and Poland. It doesn't belong to Cameroon. Tanzania, the same. And of course, COVID-19 has exacerbated that. Let me draw to a close. Must be, what is it now? I can go on for another half hour. Who agrees that I can go on for another half hour? No, I won't do it, ladies and gentlemen. I'm going to go on for another 6 minutes because there will be questions, Professor Katharina, will there? Alexandre, will there be questions? Excellent. Give me 6 more minutes. I want to wrap up. The most important thing that has happened on our continent regarding LGBTIQ rights wasn't South Africa's adoption of the 1994 Equality Clause, including sexual orientation. It wasn't even the survey which shows that a majority of all South Africans everywhere support constitutional protection for queers. It was a resolution of the African Commission on Peoples and Human Rights in 2014. 22nd of May 2014, Resolution 275, which adopted a resolution against all forms of violence and oppression against all people on the grounds of sexual orientation and gender identity, and any sequelae, forms of violence and discrimination. Botswana, I'm going to leave out the Kenyan cases, and the Botswana case, which, like the Kenyan case, insisted on associational rights for queer rights organizations. I want to tell you about someone whom I haven't met. He's a man called Judge Leburu. He's a Setswana-speaking colleague just across 4 hours from here in Gaborone in Lobatsi, where the High Court sometimes sits. And in June 2019, let me get it, 24th of May was the Kenyan case. I've lost my notes about Judge Leburu's decision. It was a 3-judge decision which struck down Botswana's anti-queer criminal law. But he did more. He said, this is not un-African. He did more. He said, our legal system should welcome diversity. It is a wonderful decision. You can get it on the web. You can look at it if you want to see it. The Southern African Litigation Center, SALC, has got it on their website. Read that decision. It's a beautiful decision puncturing the hideous lie that this is not an African thing, that this is something that doesn't deserve African dignity and inclusivity. And why is it so important in Africa? Rwanda. And when I say Rwanda, I'm not speaking about the 800,000 murderous deaths in 1994. I'm even speaking about Rwanda now. Ek gee nie om dat ek so contentieus is nie, Professor Schoeman. I'm asking Professor Schoeman for permission to continue being contentious. President Paul Kagame, he gets 98% of the vote in Rwanda. Wouldn't you like 98% of the vote when your deanship comes up for renewal? 98% of the vote, please. Rwanda still represses diversity. The opponents of President Kagame mysteriously die in Cape Town and in Johannesburg. So that is the alternative. We have alternatives to diversity and plurality, Professor Katharina. We have alternatives. The alternatives of Yugoslavia, of the Holocaust, of the Rwandan genocide. They're the alternatives of the slave trade, for which neither the English nor the Americans have yet accounted, nor the French, I might say. There are French historical roots in the subordination of black people to slaves, to slavery, enslavement. So those are the alternatives. Let me tell you, I'm going to ask you something now. I'm going to tell you something, and then I'm going to ask you to do something. Archbishop Desmond Tutu, you've all heard of him. I want to smile every time I say his name. I'm going to tell you now. He said, on a continent that has been afflicted by abusive leaders, tribalism and ethnic strife, famine, flood, malgovernance, dictatorship, military coups, corruption, genocide, and civil wars, the least of Africa's worries are same-sex oriented persons and same-sex love. Now, it's his 90th birthday today. Can I ask you to get up? And Elsabe, wil jy nie net I'm going to ask Elsabe to take a pic, and then I'm going to ask you all to salute Archbishop Desmond Tutu. He is a magnificent human being. Without him and Simon and Cordy, we wouldn't have got sexual orientation. He supported it in the early 1990s. Can someone take a video? Is there a video of the audience, not of me? Won't you get up for Archbishop Desmond Tutu's 90th birthday? We're going to send that to him, and I think his staff in the foundation will give it to him today. So thank you. Let me finish. Let me return to the role of the law. The law, like a double-edged sword, can be used, like it was under apartheid, to strip people of their rights, their equality, their dignity. But on the other hand, it can also be used to enhance human capabilities and opportunities, to secure rights, to protect freedoms, to afford dignity, and of importance to us today, to enhance diversity. That is what we seek to do in our constitutional state, in our perilously preserved democracy in South Africa. And I congratulate you on being here. I congratulate you on your conference, and I thank you for the opportunity to speak to you. Thank you.
Justice Cameron, thank you so much for being here with us today. What a privilege to listen to you, and I would have you carry on all afternoon if I had my choice. Thank you also for those historical perspectives and the context of your presentation. It is sincerely appreciated and valued to have someone of your stature engaging with us. And we know that you are so committed to this cause, and it is thanks to you that things have progressed in our country in the way they have. So also from all citizens in this country, thank you very much. And I would like the audience to give Justice Cameron a good round of applause, please. And so, Justice Cameron, in this session, we do not torture our speakers with questions, but I'm sure when we have tea shortly after, you will be happy to talk with people if they want to approach you. But thank you again for your contribution, and thank you for setting the tone for this Congress in such an inspiring way, that we will have open and frank discussions, because that is the only way that we can move forward. And it's the only way that we can make this world a better place. Bit by bit, we will succeed, and we owe that to the next generation. Thank you again. Ladies and gentlemen, I would like to invite you all to some refreshments. There is a brief break in the program, so please, in the foyer, help yourselves to some tea. For those people joining us online, surely you will also be in a position to get some refreshments. Thank you. We will be back in 15 minutes. Thank you very much.
Transplants and Development. My name is Makan Moinsbeng. I'm a professor at the University of Geneva, and I will have the pleasure to chair this very first panel. I would like to thank and congratulate our president, Professor Boele-Woelki, and Dean Schoeman, and our Secretary General, Professor Fernandez Arroyo, for putting in place such an excellent and stimulating program. Of course, when we speak about diversity and plurality in law, the issue of legal transplants is very essential to understand the processes and the mechanisms for plurality and diversity in any legal system, may it be domestic legal systems or the international legal system. So I think it's very good to start with such a panel on legal transplants, but also the role of technology and development at that level. Since we have very limited time for our panel, I would suggest to turn directly to our four great panelists for today. And to set the scene of the discussion, I would like to give first the floor to Professor Olufun Milayo Arewa from Temple University in Philadelphia, who has published very recently a book entitled Disrupting Africa, Technology, Law, and Development. And I think, Funmi, we are all very much looking forward to your presentation that would allow us to set the scene and maybe put the basis of the discussion. So without further ado, you have the floor. Thank you very much.
Thank you very much. Thank you, fellow panelists, and also thank you to the International Academy of Comparative Law. It's a pleasure to be here this afternoon. So I want to start by talking about some background issues that I discuss in my book, that are quite relevant to thinking about the intersection of law, legal transplants, and technology. So in my book, I talk about two distinct but interrelated problems of law and policy that raise critical issues related to legal transplants in our digital era today, where technology seems to drive a lot of different things. So the first problem I talk about is a global problem, and I refer to that problem as digital era regulatory, legal, and policy mismatch. And that means all over the world. The focus of my research is Africa and also the United States to some extent. But all over the world, we have a global problem of how do you regulate the use and proliferation of new technologies, devices, and the associated infrastructures. And there's a key problem of what models do we use to regulate these new uses of existing technologies and technologies that are actually new and novel. So we have global discussions today related to the broader question of governance. And I think Facebook is a leading current example for the global regulatory problems posed by digital economy behemoths, many of whom are based in the United States. Many of these companies are larger and more powerful than many of the countries where they operate. They may have little or no regulation in their home jurisdiction, depending on the model of regulation that's applied in that home jurisdiction. And they may actually cause significant harm to democracy, institutions, and people. Notably, Facebook, the vast majority of Facebook users, 90%, it's estimated, are now overseas. Now, Facebook has billions of users. So it's one of the biggest global forces that we've seen ever in terms of its reach and impact. And I think that was noticeable when Facebook went down earlier this week. And Facebook also owns WhatsApp and Instagram. And WhatsApp is used widely, and in my experience, more outside of the United States than inside the United States. Instagram is also used widely, as is Facebook. So there are broader implications of this global regulatory problem. So we have key issues related to law and governance. I'm going to highlight some of the issues that we see in African contexts that particularly raise issues related to legal transplants, issues related to privacy law, intellectual property law, business and commercial law, and also human rights law. I want to draw attention to a report from last month by the UN High Commissioner for Human Rights on AI and human rights. And in discussing artificial intelligence and human rights, the report highlights the significant human impact we're seeing from various kinds of technologies that automate various activities, particularly artificial intelligence algorithms. Now, in African context, this widespread problem of digital era governance and law and policy and models is exacerbated by what I refer to as colonial era overhang. So in many African countries, colonial era overhang reflects a legacy of exclusion. It reflects top-down approaches to lawmaking, and it reflects patterns of what I refer to as double marginalization. Now, double marginalization refers, first of all, to the exclusion of African countries from global power relationships. And this is something that obviously goes back to colonialism and even the period before colonialism. And it has legal transplants are an important part of that legacy of exclusion, because in many respects, my particular research, I'm an anthropologist and a law professor. My particular research looks at, does archival research on legal borrowings during and after colonialism, with a focus on Nigeria, but my larger focus is on former British colonies. And when you look at processes of lawmaking during colonialism, law, especially in the business and commercial realm, came externally and was pretty much adopted in many instances verbatim from in British colonies, English law precedents, or from precedents and examples and models in other British colonies. So the exclusion of African countries from global power relationships is reflected in top-down lawmaking processes that started during colonialism and that haven't ended. And notably, at the time of independence, most of these legal frameworks were just carried over into the post-independence era. And in many instances, with a few notable exceptions, including South Africa and Rwanda, we've not seen significant reform of those external legal frameworks, or sufficient reform. Now, that's the first part of the double marginalization. The second part of the double marginalization relates to the exclusion and marginalization of a majority of the population in many countries in Africa. And this is something that coronavirus has made much worse. Poverty rates all over Africa have increased as a result of coronavirus. And in patterns, coronavirus also points out these patterns of double marginalization. If we look at access to vaccine, the lack of access to vaccine that we see in many countries in Africa highlights both the first level of marginalization of African countries and the second marginalization, because this has significant human impact and lack of access to vaccine. So models of governance, policies, and law developed during colonial era with an external orientation and external sources of authority continues to be active in many African countries. Today, there are many varied sources of law. It could be former colonial powers, it could be other powers, could be NGOs and other sources. So what my book really focuses on is what I refer to as problems of borrowing that come from how you undertake the process of legal transplants. And what I also highlight is that there's a need to pay attention to what models of law and regulation are being used today, particularly in the digital era, because we have similar patterns of external, what I call external determination in the digital era, from potentially very narrow sources of models. And I talk a bit about what I refer to as digital colonialism. And if we look at the activities of companies like Facebook, Google, Facebook and Google, for instance, not limited to those two countries, those are two companies, those are just two companies I'm highlighting. It points to continued patterns of external determination, albeit coming from different sources today, perhaps a wider range of sources, but some of those sources are very narrow in orientation and background. So the key issues I want to highlight in my remaining time are, what are the continuing implications of the process of legal transplantation that occurred during colonialism, the continuation of that process or similar processes post-colonially? What are the implications of this? Well, one of the implications are that we have, in some respects, we have legal frameworks that may not be as cohesive and coherent as they need to be. So we have, for instance, in many former British colonies, we have English law frameworks drawn from English law and laws of other colonies that speak to particular areas, business and commercial law. We have customary law that was assumed to be of long duration and unchanging. And it was based on assumptions that ignored the way, I think Martin Chanek has written quite a bit about this, that ignored the way customary law responded to colonialism. So conceptions of customary law were not fully developed. We have inadequate conflict of law doctrine. We have problems with substantive law and process. And we also have unchecked executive power as being one legacy of what I call the colonial overhang in many African countries. We also have the ways that lawmaking during colonialism, lawmaking and other policies during colonialism reflect what I refer to as a portfolio approach that reflected the needs and priorities of external powers. At the time of colonialism, it was the British sort of imperial power or colonial power, rather than those emerging from local context. And this was important. This portfolio approach was important in decisions about laws, about crops, and other things. And it underscores some of the questionable legal processes that emerged during colonialism, that some of which continue. There was also, during colonialism, a lack of care in drafting and structuring legal systems, reflecting what I refer to as a cut and paste legal approach. And this is particularly a problem in that it meant that laws weren't sufficiently customized for local context. Robert Seidman, legal scholar, has a very interesting example from the criminal law area. And he notes that in 18th century England, poachers and brigands sometimes put burnt cork on their faces so that their faces wouldn't gleam in the moonlight. And many African penal statutes during colonialism that were copied actually copied the fact that it was a felony to be found wandering about at night with intent to commit a felony with one's face blackened, because people really weren't paying enough attention to what is the local context into which this legal transplant is being taken, and what are the needs in that local context, and what might we want to change in that legal context. The other issue for legal transplants that we need to think about is what kind of understanding do we have of our own legal system if we undertake to transplant it elsewhere. And I think one of the things that was highlighted, I think, in some of Martin Chanek's work is that in Zambia and Malawi, for instance, it's not clear that the people doing the transplantation really had a clear understanding of our own legal system, of their own legal systems. And I think similar patterns can happen in the contemporary era as well. We have understandings of our legal system that may reflect a formal understanding of what laws are on paper, but not necessarily an understanding of how they actually work in practice. Now, how you translate in the context of a difference between law on the books and law in practice is, I think, something that we need to query to a greater extent when we undertake legal transplants today, because that's still a problem, a pertinent problem that needs to be really thought about. And this all underscores the need to pay greater attention to local contexts in the legal transplant when undertaking legal transplant policies and legal transplant activities. There's often insufficient consideration of the local in legal and policy context, leading many people to be actually invisible from a policy perspective. Now, Jenna Burrell, who is a writer in the information technology arena, she has a book where about invisible users in Ghana. And I think her conception, she talks about invisible users in internet cafes in Ghana, who reflect the masses that are invisible from the perspective of policymakers. It's important to render actual human beings so that they're not invisible, and so that when we create laws and policies and when we transplant things, we're really taking into account what kind of people exist at the local level and how do we need to adapt legal transplants to that local level. So I want to end with 2 points to talk about 2 things that emerge out of my work relating to colonialism that I think are relevant in post-colonial periods. One is that we need to think about capacity in law and capacity in development when we're thinking about legal transplants, because there are often problems of capacity in terms of thinking about legal transplants. In the colonial era in Nigeria, for instance, in the early period, we had the transplantation of a legal system that few people understood, few people spoke English, and few people had the opportunity to develop capacity to speak English. The law was often applied in an arbitrary fashion against which people had little recourse. And this draws attention to the role of intermediaries. And I'm going to end by saying that we need to think about who are the intermediaries that function in the transplantation process, be they external experts or internal elites, and what are the interests of those intermediaries, and how, to what extent do those intermediaries take account of local people and local needs. So as we know, colonialism relied on internal intermediaries to a significant degree because of cost and minimization. And that led to opportunities for jurisdictional arbitrage, which people that knew the new system coming in and understood existing local systems, and they basically profited from that difference. Anthropologist Elizabeth Colson notes how internal contestation played out in the development of customary land law in contexts where scarcity became a factor, and when people became aware of the conflict between the old political obligation to maintain general access to adequate resources for all citizens and the possibility of extracting an individual profit from areas preempted under the rule that a man might enjoy the fruits of his labor, which is Lockean and comes out of English law, many people were able to take advantage of that. We need to minimize opportunities for jurisdictional arbitrage in the legal transplant process. I'll end there. Thank you very much.
Thank you so much. Thank you so much for this fascinating presentation and for setting the scene so well. Funmi, I think you have really pointed out some of the challenges that African countries in particular are facing when it comes to legal transplants, and I think that the themes of colonialism and marginalization are very interesting to explore. So let me now turn then to our next speaker, Professor Michele Graziade from the Università di Torino. Michele, what do you think about what we have just heard? And in particular, do you think that imitation is the way to go when it comes to legal transplants in a context of development? Thank you.
Well, thank you, Makane. It's a pleasure to be online with you, if not right there. The observations that my colleague just formulated are, to me, very relevant. And basically, I think I share her views. I've been studying legal transplants for a while by now. Most of the literature on legal transplants is not dealing with development, not dealing with technology. Most of it basically retrieves information about the genealogy and the traveling of certain laws, surely in complex context, quite often, where we find change, but we also find resistance, exploitation, transformations under conditions that are very different from place to place. So it's also quite difficult to generalize about what comes out of this literature. I just want to make a few observations, basically the following one. If we look at this literature, we find a parallel, which is to be noted, in my opinion, with the literature by political scientists about transplants. They don't call it like that exactly, but surely if many countries nowadays have smoking bans, this is because a policy was devised and eventually it turned into a legal rule, but surely the policy was the first choice. And political scientists have done a huge job in this respect. We also know that economists have started playing with the notion once they understood that institutions can be important for economic development, for development in general. And what I wish to point out, and this is also why imitation now is a strategy that is probably beating a retreat, is that the very notion of development, of course, has changed since the old times. I don't need to insist on this, but we have a view of development nowadays that is completely different from the one we had once the discourse about transplant was initiated. This, of course, includes a new and fundamental issue, that is to say, the environment, the protection of the environment, and the ability of future generations to live under conditions that we are setting now. So the quality of development has become a huge issue. And I think that discourses on transplants that ignore this are dangerous and should be challenged. So changing what development means also is changing how we should think about the transfer of laws across the globe. We all know that starting from 1989, there was a huge push for imitation. This was what I would call the age of imitation, under prescriptions that were fashioned by the economists with the help of global institutions. Now, this has not been a very successful venture after all. And in particular, it has not been a very successful venture for Africa. We know that countries that did not follow this prescription thrived, while several countries that followed them had very serious troubles. And the pandemic just highlighted the inequalities that those policies exacerbated. So now economists, or at least some of them, are taking stock of this, and they are claiming that the policy of one size fits all is not really the best policy to work on these issues. The world, in my opinion, is no more divided between norm givers and norm takers. And if I may refer to your work, dear Makane, your article on Africa's voice on the formation, shaping, and redesign of international investment law is exemplary in this respect, showing the contribution that African states are bringing to the table of investment treaties. I don't have the time to cite you as I should, but I wish you to make clear that I did read your work. And I found it precisely relevant to our team today. We could bring in more examples of these kinds. Surely the position of India about the TRIPS agreement is telling a very interesting story, but I don't want to, abuse the time I have. So the other point that I would make is that the neoliberal agenda of the 80s hid under the carpet one of the most important aspects of the historical record. And this is that the fact that economic development in the West was not necessarily bound up with strict uniform enforcement of, say, intellectual property rights or even property rights to court. Just to put the case of Italy and to speak of a topic of present importance, up to 1978, my country prohibited patents over pharmaceuticals, and yet we had a pharmaceutical industry. It was a constitutional court judgment pushed by foreign pharmaceutical firms that brought in the issue of allowing patents over pharmaceuticals. We lived for over 150 years without granting patents on pharmaceuticals. So don't think it's a new idea in a sense. Now, to return to this story, surely certain transplants or global approaches do not simply raise objections on concerns abroad. As Fumi pointed out, we have to have a proper understanding of what legal systems do even at home. And I think this is an important point. Speaking about innovation, for example, we know that we are now living in the age of superstar firms. Now, to cite research in the Harvard Business Review, surely not a Marxist leaflet, there are companies like Google, Samsung, bienvenue, to name a German firm for my friend Ralph Michael over there, that are top players in the respective industries and they are prospering. But if productivity is soaring at top firms, it is sluggish elsewhere in companies that cannot catch up with this rhythm of technological innovation. The result is that this is a market where winner takes all, and where at the end of the day, even though expenditure for research and development is growing, it is growing in the aggregate, while at the level of medium-sized firm, the situation is completely different. And so more rather than less inequality is to be expected, and we should ask, and I think that in Washington they are beginning to ask whether this is sound policy or a policy that will backfire. Now, of course, technology is an essential component of all modern economies. The impact of technology will be immense. Africa will do its part. I have no doubt about this. And then the question is, shouldn't we think about returning to a view of the state that is central to innovation and to manufacture, in other words, to the production of wealth. One of the most impressive transplants of the last decades was the diffusion of narratives symbolized by catchwords such as get incentive rights, do away with corruptions. These are narratives which extol the role of markets, but now we also realize that tend to reduce the state in the economy, to do away with bureaucracy, reducing the size of public administration, and yet private ordering is not enough to have development. I wish to remember the tragedy, like the tragedy of the Rana Plaza collapse, building collapse, and this was an horrific tragedy that shows what happens when the state is not there. So it becomes clear, as Fumi said, that capacity building is a key to development, and the role of the state remains vital. I think that the African Bank for Development is pointing in this direction, and leading economists like Professor Ha-Joon Chang at Cambridge are insisting on similar point. I'm not inventing. And maverick economists that defied the leading views pointed to the way of how China, South Korea, Vietnam developed by exactly playing this strategy. So I don't want to spend more time on this. To be honest, some transplants are based on policies that are considered to be problematic and controversial at home as well. And then the rule should be do not do unto others what you would not want done to you. Thank you so much.
Thank you very much, Michele, for this very powerful speech, but also a speech with a lot of hope, since you're seeing developing countries as having the potentiality or the capability to go beyond their usual position as rules takers and rules consumers when it comes to development. I think it's very good to hear that, and many states would actually need to hear such powerful messages in the developing world. So let me now turn to Professor Danwei from the University of Macau and hear about a vision. Should we be that optimistic, that hopeful? And what is the role of technology? We heard a lot about how legal transplants actually can affect the very idea of development. But when it comes to technology, how do you see its roles in relation to legal transplants? Thank you so much, Danwei.
Thank you, Chairman. First of all, my hearty thanks for the organization committee for giving me this wonderful opportunity to join in this panel. Since the publication of Legal Transplants, an approach to comparative law by Alan Watson in the 1970s, legal transplants have always been the basic question of comparative law. And even today, they still remain to be the core issue for comparative lawyers. The imbalance between the social development and legal development determines the inevitability of legal transplants. Legal transplants are also an inevitable requirement for the modernization of the legal system. The ultimate requirements of socioeconomic development enable a smooth progress of legal transplants. Horizontally, they can occur through mutual borrowing among countries with a similar stage of development, or through total absorption by the former colonials or less developed countries. Vertically, with the impact of globalization and global governance, countries are bound by global norms such as international treaties and conventions, and legal transplants always relies on top-down approach. The metaphor of legal transplants should be used in a broad sense. In the process of globalization, concepts of global governance and rule of international law began to take shape and gain force. The localization of foreign laws and globalization of local laws pose a challenge to the governance models of nation states. These new trends have a great impact on the legal transplants. We can say the theoretical paradigms of legal transplants should be adapted to answer these new challenges. These theoretical paradigms vary with different types of societies. For a primitive society, a cultural paradigm worked. For traditional societies, between the formation of the state and coming of a modern age, a political and cultural paradigm took shape. For modern society at the nation stage, a political paradigm was well applied. And now for a globalized society, I think the ideal paradigm should combine the economic, the political, and with common human values. In light of the demand of modernization and globalization, in particularly in Asian countries, the debate on reception of law and legal transplants is no longer a pure strategic or tactical question. The need of legal transplants have shifted from a purely curative demand, or we can say a method of governance, to a targeted demand of social transition from tradition to modern. As regard to social changes, law is both a reaction device, and a driving device. Nowadays, in many Asian countries and regions, the rule of law is actively promoting social changes, is gradually increasing. Many times, law is still believed to be a tool, but the legal development mode, including legal transplants, have been loaded with external objectives. Legal transplants have been given a belief in the development of law and the nation state. As a result, legal transplants are no longer just original technical question. They are also endowed with value demands. Legal transplants is a process of making the black letter law into the law in action. In other words, it involves the transformation from text-based norms into practical operation in host jurisdiction. Its effectiveness largely depends on the artful usage of technology, which is the sum of techniques, skills, and methods. In our opinion, at least, I think 5 pitfalls shall be avoided when we use the technology, the broad sense technology of legal transplants. The first pitfall is the concept of the linear progress of law and development. In our complex world, the development path of different countries and societies are highly diversified, and there are too many distinguished variations affecting the economic, social, and legal development. Legal factors need to draw support from other factors such as politics, economy, and culture in order to play its role. The second pitfall is the concept of legal instrumentalism, according to which law is always viewed as an instrument to promote economic development. In the short run, such utilitarianism is conducive to legal transplants by reducing the difficulty and simplifying the process, and can attract the support of profit-seeking merchants and multinational corporations. However, in the long run, the concept of legal instrumentalism ignores the contextual factors and related values behind the law and might cause strong resistance from specific groups in the host country. The third pitfall is to avoid the hidden colonialism. Legal transplants sometimes have been criticized being a part of history of colonialism in the 19th century and neocolonialism in the 20th century. The required techniques of legal transplants in nowadays aim to provide public goods, which are easily accessible and easily adaptive in different countries and societies. In the fourth place, there's no one-size-fits-all approach. No model is universal, and no model is perfect. Legal transplants shall go hand in hand with legal reform and support each other. And the exportation and the importation of legal norms need to be complementary to each other. Last but not least, legal transplants cannot be perceived as the exportation of legal ideology. Legal ideology can refer to an in-depth and common consciousness of specific legal professions in a given society. In fact, legal practitioners and legal professions in any country have formed their habitual ideology. The experiences of law and the development movement in the US taught us that legal transplants were closely related to exploitation of legal ideology. Nowadays, legal transplants is so widespread and ubiquitous. Even though some involve legal ideology, more phenomenon combined with different concepts and ideas and show ever-changing appearances. In this sense, the binding effect of legal ideology on legal transplants is very limited. In our global world, legal transplants in many developing countries have a lofty mission for achieving objectives of modernization and development. Legal transplants require intrinsic needs, external conditions, and a number of promoting presuppositions. Their success depends on benign interaction between the legal norms themselves and the political and economic conditions, and also the overall legal order in the host country. As comparative lawyers, we want to highlight the state-of-the-art technology is always the guarantee of successful legal transplants. We need to rethink the innovative methods or techniques and promote the technology per se. In a diversified context, the operators of legal transplants not only need a selective approach, but also ensure the inclusiveness, adaptability, and flexibility of the transplanted norms. In this sense, the meaning of technology hides deeply between the possibility and the impossibility. Thank you very much.
Thank you very much, Danwei, for this very insightful presentation, and also for sending a very clear message on how you see that the state of the hard technology as a guarantee for successful legal transplants. And this allows me now to turn to our last but not least speaker for this panel, Professor Ralph Michaels, Director of the Max Planck Institute for Comparative and International Private Law in Hamburg. Ralph, what do you think about the last one made by Danwei? Should we see legal transplants as a technology transfer? Thank you, you have the floor.
Yes, thank you, Makane. Thank you, brilliant co-panelists. I had been really excited to sit on a panel here in Cape Town with all of you. In fact, I'm sitting all alone on a stage here. I am the physical panel here, and I feel a bit lonely, and I'm glad to have you at least on the screen. Yes, if we look at the title of this panel that combines legal transplants, technology, and development, we immediately think that ways in which we have tried to spur development are in part through legal reform, and that is often legal transplants, and in part through technology enhancement and technology transfers. And much of the colonial issue of transplants, as Professor Marewa has pointed out in the beginning, was about avoiding development, about extraction, and about legal transplants as domination mechanisms. And the hope in the benevolent 20th and 21st century is to not do the same thing, and yet we see the challenges of global north, global south inequalities, of problems of neocolonialism, etc., and of the involvement of both technology transfer and legal transplants law reform within those. And I want to suggest that actually legal transplants and technology transfers are not that different from each other, in fact, that it would be fruitful for us to view legal transplants themselves as a transfer of technology, because it would help us both understand things about legal transplants and critique them in better ways. What would it help us understand? A core point that I think Professor Danwei in particular pointed out: how does law actually operate in the world? How does actually the transfer of what she calls law in the books turn not just into law in action, but actually in developments in societies, in economies? And that is in fact not so clear. It's even less clear if we look at legal transplants understood as laws traveling. Now, if we look at the legal transplant literature, Michele Graziadei pointed that out already, it's deficient in some ways. And one I would suggest is much of the debate is about concepts of law, and these concepts of law themselves tend to be deficient. So when Alan Watson speaks of transplants as being omnipresent, as he understands transplants as a copy and paste, and this concept of law is really laws as rules. If Pierre Legrand opposes that transplants are impossible, it comes from a different concept of law that he understands as law as culture in a broader sense. If Suji Chowdhury speaks of transplants as the migration of ideas, then his suggestion is that law is really consists of ideas. When Gunther Teubner understands transplants as irritants, then his underlying concept of law is law as discourse. And of course, Michele Gazzarè introduced the idea of law as policy before when he talked about cigarette regulation. So for all of these approaches, the understanding of law is different. In one way, it's similar in the other in that law happens as a purely ideational thing. So law happens in the world of ideas, in the world of the mind, and therefore gets juxtaposed then with actors on the one hand and material conditions on the ground on the other. So we focus in addition then on the actors of transplants, the exporters and the importers, etc. We focus on the material conditions on the ground in order to determine the perfect fit. We focus on institutions, we focus on material outcomes, something that the World Bank tries to measure as impacts of the law. And in doing that, we separate the law from its actors and from materiality. And so we tend to both overestimate or underestimate the role that law actually plays towards development. We grossly overestimate it if, as did the authors, the economists in the legal origins concept, they suggested a direct avenue from legal rules or legal origins towards economic outcomes, as though there were no materiality involved in translating these ideas, which they understood law to be as pure rules, into actual outcomes. Or we grossly underestimate the role of law when we suggest essentially everything is just about underlying policies, ideologies, business interests, etc., and law is just a smokescreen. So those are really shortcomings, I would say, of understanding of law as purely ideational and as being opposed to actors on the one hand and material on the other. So the suggestion, this is the second part of my remarks, is really to draw on work that Annelies Riles in particular has introduced, mostly by herself, some of it also with me, to understand law as technique. And what she means by law as technique is really a whole package, a package that concerns a certain ideology of instrumentalism and managerialism, certain categories of legal experts, technicians, if you want, scholars, bureaucrats, attorneys, judges, who treat the law as a kind of tool or machine and see themselves as modest but expertly devoted technicians who translate into outcomes. A problem-solving paradigm that treats law in some ways as a means towards an end, that defines practical problems and uses the law to craft solutions. A specific technical form of reasoning and argumentation that is remarkable, actually. The fact that we figure that through pure words and legal rules, etc., we can achieve things like create rights, transfer ownership, etc., etc. So a particular way of argumentation, and then a set of material artifacts, not just court buildings, but boilerplate agreements, contract forms, indeed, etc., etc. So all of that would be an idea of law as technique. Now that draws, of course, to some extent on ideas from science and technology studies. And it suggests really a coexistence, if you want, of the ideational, as I called it, and the material on the other. That is, the materiality of the law and the sociality of law are really produced together. Concrete example from the work of Alain Portage from the London School of Economics is to suggest that patent law is not merely ideational. It's a mode of fabrication through which inventions and their owners are constituted. In other words, inventions are not just ideas and they are not just non-legal science. They are at the same time intrinsically interwoven with the law, with patent law itself. And that, secondly, provides law itself, the legal form itself, with its own form of agency. So to some extent, it is patent law itself that participates in the creation of inventions. It is not just inventors, it is not just patent attorneys, it's the legal forms itself. Now, if we understand law as technique in this sense, then we can see, thirdly, of course, that legal transplants become transfers of technology. It's not merely rules, it's not merely actors, it is actually the techniques themselves, the technologies themselves that are transferred. In a way, similar to the way in which other technologies are transferred, of extracting mines, of running code on the internet. The law also becomes this technique that has its own existence. And of course, the example that Michele Graziadei mentioned before, the TRIPS example, is a very important example in the pandemic. We have the dramatic inequality of vaccine access between the global north and the global south. And a large part of that comes, of course, through patents and through patent law. And one response that was requested was to say we have to open up patent protection. And one response was to say we cannot do that. First, it won't help. And second, it would undermine the very system of patents that creates the very incentives to invent in the first place. And I want to suggest that this counter argument is not entirely wrong. It's not entirely wrong in the sense that if Potage is right and inventions are co-produced by inventors and the patent law system, then all these inventions, including the vaccines, already come with a legal baggage. They already have their law with them. And so the exportation of vaccines always comes with the exportation of laws in one way or other. And in that sense, then, I think we can say that we can also formulate a more radical critique, if you want, of this system of injustice, because we can say it's not just the problem that TRIPS is universalized. It's not just the problem that in some isolation, patent laws are imposed on the rest of the world. But it's really the problem that our technical innovations themselves, patents just being the last most obvious example, are interwoven with a specific way of thinking about laws and transferring laws that is destructive, that is detrimental, that does not lead to justice. And of course, just lastly, to relate to the breakdown of Facebook and WhatsApp and all of those communication technologies at the same time, all of which are, of course, intricately interwoven with law themselves. So the transfer of WhatsApp technology always comes with law necessarily. We see the problem of monopoly there. We see the problem of one size fits all that Graziadei mentioned, not just as a problem of taking account of local cultures, but also a problem of monopolization. If indeed at some point the laws that we have turn out to be systemically destructive, and we do not have alternative laws, we see similar problems in other parts of the world, as we saw with WhatsApp and Facebook. So what are solutions? I don't have solutions. I'm interested mainly in analysis here, but I think delinking would be one of the important responses, not just delinking in the sense of taking account of local cultures themselves, but even prior to that, assuming the potential, the possibility to think law, legal reform in other ways than in modeling against northern concepts. I guess I'll stop there because we are really short in time. Thank you.
Thank you very much, Ralph, for this very provocative presentation. You gave us a lot of food for thought, and in particular, you finished with a very major question, which is the question of the solutions. So since we have a few minutes remaining for this panel, I would like to turn again to some of you on how do you think we should undertake future approaches to legal transplants in light of the past experience? Ralph was suggesting now the idea of delinking. So what are the other views here on the panel? Funmi, would you like to jump on this question, please?
Yes, I think that delinking is, I think, a nice way to think about how we structure our approaches. I actually, the title of my book, Disrupting Africa, is actually about two parallel things. It's about disruptive technology and some of the destruction that we've seen coming with disruptive technology, but it's also about the need to disrupt old patterns of approaching the implementation of law and policy and models. I think we have to think more broadly. We're seeing parallels. It's not just law or what's written with law, it's the assumptions that come with it. It's a question of process. So I think we really need to think about, we tend to think about law as something that's written down. And so much of what's written down reflects a process that occurred in the place where the law came from. And when you transplant that law, you're transplanting that history of dialogue, controversy, compromise that comes with that legal transplant. I think if you have a more process-based approach, you ask, what is legal transplant as a matter of process? What has it been in the past with top-down, dominating, top-down laws coming from powers that intended to dominate and exploit? What was the process from where that law came from? What is the process in the place where we're going to take it? And we also have to look more clearly at outcomes. I think one thing in law, we're not very good at looking at outcomes. People talk all the time about, for instance, just the debate about patent and incentives. We don't know a lot about intellectual property and incentives. Even in the places where intellectual property, the global norms that got translated, the places where it comes from, there's a debate about copyright and incentives to create, patents and incentives to innovate. So I think we need to think about a more process-oriented approach would tell us we need to look at the process of where it came from. What are the dynamics there? We need to look at the process where we're taking it. And we need to look at the process of transplantation. Who's involved in that actual process? Who are the experts? Who's considered to have expertise? Who do we listen to? Whose voice is heard is a matter of a process. Whose voice is at the table? And I think a focus on process, if we focus on the right kinds of processes, can take us in a direction where we query more critically the whole legal transplantation process, from origin source to the process of transplanting it, to the process of implantation in a new place. And then I think we also have to be continually attentive to outcomes and think about more flexible approaches. In my book, I suggest we need more experimental approaches where we experiment, do something and see, does it work on a small scale, hopefully to start, and see, does it work, and really have better ways to measure outcomes, because I think in law, we don't measure outcomes very well generally.
Thank you very much, Funwi. Danwe, you've been very critical of top-down approaches in your presentation. So how do you perceive the future approaches to legal transplants? I think you have to start with the local, I think, to a greater extent, and look at what are the needs of the local. And in transplantation, you might need to mix things up. We often, in transplantation, it's based on some assumption about where we're going to take the law from. I think, and this comes out of my music work, we need to think about remixing the law, specifically attuned to particular contexts with an understanding of the historical experience, where it comes from. The experience we heard about in Italy with patent law, which had been done earlier in European countries in the 19th and early 20th century, that did not actually have patent law for certain types of innovations. So we need to, I think, look at law from both a historical and contemporary perspective, and look at what do we think worked in different contexts, and how different is that earlier context from the local context where we're looking at. And I think we really need to query how experts are used, and I think the technique that I think Professor Michaels talked about, the technique and process by which expertise is brought to bear on a particular problem. And I also think we need to think about questions of accountability. Who's accountable in terms of the legal transplantation process? Is the person that actually is guiding this, do they just go away and then whatever's left is just there? I think we need to think about law as a process in motion, and be ready to modify law when it's not really working, or where local needs may have been miscalibrated or may have changed. So I think a more flexible approach that focuses on process and that queries every step of the process. Thank you, Funmi. So I would be very happy to hear Danwe's views on the remixing suggestion.
Thank you. I fully agree with the remarks of Professor Raff. Law should be treated as technique. So the legal transplants shall be also viewed as a kind of offer of public goods. So I would like to propose two different future approaches. The first one is to diversify the operators of legal transplants, because in the past, maybe the past experience was led mainly by the top down, by the governments, and also from the top level. And from now on, maybe it's more effective. We diversify the other operators, such as the NGO, legal professions, academy, and also legal entrepreneurs in a broad sense. And the second approach I would like to propose is to diversify the sources of law. In addition to the official law, maybe it's very interesting. We look at the customary law and other informal law of different societies. Thank you.
Thank you very much, Danwe. And just maybe to finish with Michele and Ralph, what do you both think about technology? Do you think that a certain technology will by itself bring about a certain way to regulate the field in which it must be used? If you could jump on it, maybe Michele quickly, and then we will finish with Ralph. You are muted, Michele.
A very quick answer to this very intriguing question. Of course, there's a link between a certain technology and a certain form of society to a certain extent. You know, this is a classic, but this should not be overstated. For example, the way data protection is regulated in the States and in the European Union is not the same. And I wonder what path will Africa follow. The European Union is now pushing for Africa to buy the same approach that is prevailing in the Union. But of course, it's hardly feasible under African conditions for many ways, as my doctoral students are explaining me, doctoral students from Africa. So I do think that there's a certain link between technologies and laws. You know, the revolution of the Neolithic brought the early states on the stage. Previously, we were not living like that. So, but there's still choice. I think there's still the possibility, you know, to follow different paths, even in the most technologically advanced solutions. We also make value choices that in part depend from the society we are. The way the US regulated data protection relates to First Amendment and to a number of other things that don't exist in other countries.
Thank you very much, Michele. A last word, Ralph, before we conclude?
So maybe on the parallel, what any law reformer faces a similar problem like the head of a company, which is the old Coasian asked question, make it or buy it, right? Do I make the technology myself or do I buy it somewhere else? The same with law reform, do I make laws myself or do I buy them somewhere else? And the tendency has been towards universalization of technology because of network effects. And the same is, I think, something that we can see in the universalization of law. There are network effects. There is an interest for a country like South Africa to borrow US models of antitrust law, for example, and then for a country like Malawi to borrow South African antitrust law, even though it does not fit the local economy at all. So there are very big problems with that. I think that technology and legal technology have agency to some extent and in that sense shape. I also think that we have the possibility to deal creatively with the technology that we have. Africa in particular has a long and proud tradition of very creatively recreating technologies that were borrowed from elsewhere, from cars that are adapted to something else to many others. The same is possible in the law, especially with abstractly formulated laws. Those can be reappropriated and they can be turned into something else. And so much matters in what is done with the technology and how it is redesigned in order to establish some of the delinking, but that requires a certain level of autonomy from the pressure of the global economy. But then that is possible to adopt a transplant, but reappropriate it and turn it into local usage in the same way in which we do that with technologies outside the law.
Thank you. Thank you so much, Ralph. Thank you so much. I wish we could continue the discussion because this is really fascinating, very, very great panel. And hello?
Yeah.
Yes. No, I was saying thank you so much. Thank you so much, Ralph. And I was saying that I wish we could continue this very fascinating discussion, but we have now to conclude. Thank you again to the four of you for great presentations. I was very happy to share this panel. And I wish you all a good afternoon or good evening, depending on where you are. And thank you again to the organizers for putting in place such a great topic. Thank you very much, and bye-bye.
Bye-bye. Thank you all.
Bonjour à toutes et à tous, je m'appelle Alexandre Selenganik et j'ai le grand plaisir de travailler pour le secrétariat de l'Académie. Et j'ai surtout l'immense plaisir aujourd'hui de vous présenter notre premier duo de rapporteurs généraux qui ont travaillé d'arrache-pied depuis maintenant plusieurs années, on peut le dire, sur le thème de la diversité et du pluralisme en droit, en s'intéressant à une discipline ou une branche du droit incontournable à cet égard, les droits humains. Our two general rapporteurs on the topic of diversity and plurality in human rights law do not need an introduction, but I would still like to say at least that we have Laurence Burger-Glassen, who is a professor at Sorbonne Law School in Paris, and notably a former judge of the Constitutional Court of Andorra. And joining live from Strasbourg is Christoph Haynes, who is a judge at the European Court of Human Rights, and also a professor of law at the Jagiellonian University of Krakow. The Academy can pride itself of having selected two experts with both the academic perspective and the perspective from the bench. Without further ado, let me just briefly explain the organization of this session, which should last about an hour and 30 minutes. Christoph will start and provide us with an introduction to the general report, explaining in particular the preparatory work, the elaboration of the questionnaire, and how the research has been conducted. Laurence will then proceed with a presentation of the main findings of the general reports and discuss these findings. We will then open up for possible questions and terminate the session of the presentation of the general report. Avant de donner la parole aux rapporteurs généraux, je vous informe que vous pouvez directement télécharger le rapport général dans sa version non définitive. Je remercie d'ailleurs Bruno qui nous accompagne du secrétariat, qui va partager le lien immédiatement dans le chat. Et nous remercions évidemment donc nos rapporteurs généraux d'avoir préparé aussi cette version non définitive qui par la suite fera l'objet d'une publication dans la collection Ius Comparatum de l'Académie. Monsieur le juge, cher Christophe, je vous laisse le floor, comme on dit. Merci beaucoup. I think you are on mute.
Merci beaucoup, Alexandre. I shall speak English today. And as already mentioned, we have divided our task between Laurence and myself in the following way. I will make a short introduction to our research, focusing on the questions which are to be asked, and then Laurence will speak and will focus on the answers to the questions we ask. This is the general divide of our tasks today. First of all, I would like to thank the organizers of the conference for the invitation. It's a great pleasure and privilege to speak as General Rapporteur. I would also like to thank Laurence for her contribution. It was a great pleasure to work with such an eminent specialist in the field of human rights for the purpose of preparing this report. The task was not easy because diversity and plurality are polysemous words. They involve a large number of issues in human rights, and therefore addressing diversity and plurality in the field of human rights is a difficult task and requires, first of all, a selection of issues to be addressed. And as you know, this selection is controversial and may be criticized as arbitrary. We first note that there is an important corpus of international legal rules on diversity, and especially on cultural diversity. There are important legal instruments within the framework of the Council of Europe, such as the European Charter for Regional or Minority Languages, signed in 1992. There is the Framework Convention for the Protection of National Minorities, signed in 1994. There is also, for instance, a set of guidelines of the Committee of Ministers of the Council of Europe to member states on protection and promotion of human rights in culturally diverse societies. There is also an important set of instruments at the universal global level, such as the UNESCO Declaration on Cultural Diversity 2001, the Convention on the Protection and Promotion of Diversity of Cultural Expressions, 2005, or the United Nations Declaration on the Rights of Indigenous Peoples. So a possible approach would have been to look at this corpus of international legal rules on diversity and on their implementation into national legal systems. But this was not our choice. There is another issue, important issue at which we do not look at as such. There is a plurality of views on human rights, their philosophical foundation, their scope, the way collisions have to be solved, conflicts have to be solved between rights. So another possible approach would have been to compare the philosophical foundations of different national or international protection regimes. It has not been our choice. We have decided to structure our research around three main axes, which we find particularly important in the field of human rights. First, around diversity, which is understood as diversity of identities, the recognition of identities and protection of identities in law. This is the first aspect of our research. Then plurality, as understood as plurality of opinions, and the management of this plurality of opinions in law. And thirdly, plurality understood as plurality of legal regimes, of legal systems, which regulate the status of the individual and the way that this plurality of legal rules, of legal systems is managed in law. We also add a fourth chapter to the research, the circulation of ideas connected with diversity and plurality in the field of human rights. Then we have to take into account also another difficulty. Law is a multi-layer system. It involves several layers. It involves international law, with its regional rules and, first of all, universal rules. There are regimes of supranational law stemming from international organizations such as the European Union and other integrative organizations on other continents. There are systems of national law, obviously. There is also subnational law, especially in federal states or in regional states. Also transnational law, consisting of rules which do not emanate from states or international organizations, but consist mainly of spontaneously or created rules in some fields. We have decided to focus on two main layers: regional human rights regimes, regional human rights law, and to try to compare the regional human rights regime between them in the field of the protection of diversity and plurality. Also the supranational law created by international organizations, and first foremost, the national legal systems. We do not decided not to look at the rules of transnational law, or not to look at the subnational level of human rights protection. In my view, the most complex legal issues in the field under study are connected with the question of identity. Identity is a complex issue, a complex notion. There are many possible definitions of identity. The most simple definition may be worded as follow: identity is the sense that people make of themselves through their subjective feelings based on their everyday experiences and wider social relations. Identity is a very complex and multidimensional notion which involves subjective and objective elements. I would like to point briefly at 6 points here, which are important for the research we've decided to carry out. Firstly, identity concerns specific features of a specific subject, of a specific legal subject, and this subject may be an individual person, but there may also be a collective subject, as a community, for instance, a net or a religious community. Secondly, identity involves necessarily definition and self-perception of the subject in question. But it may also involve the perception of the subject in question by other persons. So the issue is of identity has an individual dimension and has also a social dimension. Thirdly, some elements defining identity may be a matter of free choice, such as, for instance, political self-identification or religion, whereas other may be a matter of acceptance of external factors of constraints, such as, for instance, cultural identity understood as cultural identity transmitted by the parents. Fourthly, identity may encompass features which are unique and which distinguish someone from other persons, but identity may also involve features which are common to a class or a group of persons or a community of persons. So features which unite a person with other persons. Fifthly, there seems to be a growing number of persons claiming complex identities, multiple elements, such as self-identification with two or more national or ethnic communities. And this complex identity may be in some way reflected in law. And sixthly, the question arises to which extent identity should be understood as a matter of self-identification, or to which extent identity is a matter of social identification, of identification by other persons. These two identifications may be different. In particular, a community may refuse to recognize the membership of a person who claims that she or he belongs to this community. Generally speaking, in the Western world, there seems to be a growing tendency to emphasize individual elements of identity, identity as self-identification, whereas there may be some regions in which the communitarian dimension of identity, the way other persons see a specific person, may be particularly emphasized. So in this context, the main question which arises is the question of the recognition for the different elements of identity and the scope of states' obligations connected with this recognition. Is there a right to the recognition of identity? And if there is such a right, which consequences this right entails for the holder of the right? There is obviously a negative dimension, which is relatively easy to define. Negative dimension of identity means freedom from attacks on identity, but there is also a positive side, positive obligations connected with identity. And here, there is a room for very different answers to this question. The respect, for instance, for ethnic identity requires the creation of special political institutions for the purpose of self-government within an ethnic community, or does respect for religious identity require the recognition of the legal force of the religious family law, for instance? Are there any other obligations connected with the recognition of identity as a right? Different communities based on identity may claim some collective rights linked with this identity, such as the recognition of the language as official language or language of education, or may further formulate other political claims, such as the claim to statehood, the claim to have the status of a federated entity within a federal state, the claim to regional autonomy within a regional state, the claim to have entities of local government, or sometimes the claim to join another state. So identity involves a huge variety of political solutions aimed at managing this identity. And we have tried to organize our research around these questions, and we have devised specific questions pertaining to these different aspects of identity. We have also decided to address the issue of plurality of opinions and the way the plurality of opinions is managed in the present world. And here I think two questions are particularly interesting. The first question is the question of the philosophical or ideological self-identification of states. To which extent states claim their neutrality in philosophical, ideological, or religious disputes, and to which extent states claim certain preferences, philosophical, ideological, or religious preferences. The answer is not easy and is not obvious. In my view, no state can be really neutral. Liberal democracy itself is not a neutral choice. It's not really possible to keep an equal distance vis-à-vis all competing philosophical, ideological, or religious opinions. So the idea of equal distance has limits. And this brings us to the second question, the question of the limits of political pluralism, or to put it in different terms, the question of the scope of militant democracy. All liberal democracies tend to become militant democracies to some extent, but not all democracies have become militant democracies to the same extent. And that is therefore interesting to compare the way liberal democracies and also other regimes, the way they address the issue of restrictions on the free market of IDs. To which extent the state, for the sake of protecting democracy and human rights, may impose certain limitations upon the free market of IDs and interfere with this free market of IDs, which used to be the departing point of the organization of the liberal constitutional democratic state. So our questionnaires are also structured around these two fundamental issues of the management of the plurality of opinions. We've also decided to address the issue of the plurality of legal systems and the way this plurality of legal systems is reflected, especially in the constitutional case law, how the constitutional courts cope with the multi-level system of the sources of law, international law, supranational law, national law, subnational law, transnational law, and how the possible conflicts are solved. In connection with this, there is one interesting question which deserves a short footnote here. The question of equality and non-discrimination as the main instrument for managing diversity. To which extent questions concerning protection of identity and pluralism may be solved, may be worded and then solved in terms of equality and non-discrimination. To which extent these two principles of equality and non-discrimination have to be complemented by other principles. Are all questions of identity and plurality of views at the end questions of equality and non-discrimination? Or is it so that these two principles are not sufficient to solve the issues which arise in the field of human rights connected with the protection of diversity and identities and plurality of opinions? I will not give an answer here. Finally, we decided to address the issue of circulation of IDs, and we have asked several questions concerning the circulation of IDs in the field of human rights, IDs connected with the protection of diversity and diversity of identities and plurality of opinions. And I would like to point out a few elements which appear, a few conclusions we can draw from this research. First of all, we can see that the national rapporteurs are quite cautious when they address the issue to which extent there is a circulation of ideas between their own legal systems and other legal systems. Usually the rapporteur tend to minimize the foreign influence on their respective systems, but also they tend to minimize the influence of their own domestic legal system on other legal systems, even if there is evidence from other research carried out that there is a circulation of ideas between legal systems, and even if we know how certain legal solutions or ideas or concepts were borrowed from one legal system to another legal system. So it's very interesting to note that the national reports do not really document this circulation of ideas. Of course, we do not blame the rapporteurs for this. We just note that it's not easy to evidence the circulation of ideas on the basis of the reports written for the purpose of presentation at the Congress of Comparative Law. In my view, there seems to be three channels of circulation of legal ideas and concepts. There may be direct circulation from state to state, for instance, borrowing one state from another legal system. But there are also two much more interesting channels of circulation of ideas, which are much more important, especially in the field of human rights. One channel is the global and regional legal conversation, and especially human rights conversation. Legal professionals from all over the world tend to exchange ideas, take part in a global discussion on human rights that come with concepts stemming from their own legal system. They put this into the global legal debate. The ideas start to circulate, and then they are taken from this global legal conversation to the national domestic system. And then there is another important channel of circulation of ideas, and this channel has been noted in several reports, and this other channel are the regimes, either the international global regime of human rights protection and the regional regimes of human rights protection. So ideas and concepts come from the different legal systems to the human rights protection regimes at the international level, global level, at the regional levels. The influence the case law of the treaty bodies which protect human rights, and then in turn the treaty bodies influence the legal systems of the participating state. So international human rights bodies are a very important vector for the circulation of ideas in the field of human rights, and especially a very important channel of circulation of ideas connected to the protection of diverse identities and to the protection of the plurality of views. This is probably now the most important channel. The role of international courts and treaty bodies, they are a driving force putting into motions the mechanism of circulation of ideas in the globalized world. This is an interesting development, how the circulation of ideas transforms and develops. So to conclude this brief presentation, our reports have been structured around these three main topics: plurality of legal systems, plurality of opinions, and the management of this plurality of opinions in the modern legal systems, and the question of identity and the protection of the diverse identities in the international, regional, or national human rights protection systems. We have got an important number of reports. Unfortunately, we were not able to get all the reports we would have wished, especially concerning international organizations such as European Union. But nonetheless, we have got an important number of data, important information, and I will now pass the floor to Laurence to present the outcome of this research. I would like also to take this opportunity to thank very warmly all the national rapporteurs for their contribution, for their very interesting reports, very enriching reports. Many of them have opened my eyes on problems of which I was not fully aware, and have enabled me to rethink the approach to some issues. But Laurence will speak in detail about the content of the reports. Thank you very much.
Merci beaucoup, Christophe. Je vais effectivement maintenant prendre la parole. Je tiens avant tout très rapidement à remercier encore l'Académie, l'Université de Pretoria et toute la formidable organisation qui nous permet d'être réunis aujourd'hui à Pretoria. Alors l'analyse effectivement très méticuleuse des 23 rapports nationaux et des 2 rapports transnationaux permet de distinguer en réalité 2 grands mouvements. S'il ne fait aucun doute que la majorité des ordres juridiques nationaux sont fondés sur les principes du libéralisme politique, il n'en reste pas moins que de multiples contraintes d'ordre socio-historique continuent, nous allons le voir, de peser sur les États qui ont, pour certains, beaucoup de mal à dépasser les affres du passé. Au-delà du droit, donc, il était tout à fait nécessaire de prendre la mesure de la réalité et des difficultés de l'ordre juridique, des ordres juridiques, des difficultés du droit à transformer profondément, durablement, des sociétés divisées, tantôt par la colonisation, tantôt par les soubresauts violents de l'histoire, des guerres, des dictatures ou encore des révolutions. Et nous allons donc tout de suite et assez fortement percevoir qu'en réalité, c'est l'éloge de la complexité, c'est l'éloge de la nuance que ces rapports nationaux nous permettent d'appréhender. Alors, quelques mots, si vous le voulez bien, sur la puissance de la fondation libérale. Tout d'abord, nombreuses sont les constitutions qui consacrent un ordre juridique libéral et démocratique et qui régulent les relations politiques et sociales au sein de la cité. Pour certains États, d'ailleurs, cette fondation libérale remonte très, très loin dans le temps, grâce à des principes établis dès le 19e siècle, comme par exemple en Argentine, comme l'a relevé Alejandra Rodríguez Galán dans son rapport. Et cette puissance de la fondation libérale des États engendre plusieurs conséquences. La première, c'est la neutralité affichée de l'État. La seconde, c'est, vous en conviendrez, c'est assez normal, la centralité des droits humains et des droits humains, des droits des individus, mais aussi la centralité de certains droits afférents à des groupes qui structurent les démocraties libérales contemporaines. Neutralité de l'État, centralité des droits. S'agissant de la neutralité de l'État, c'est un principe qui apparaît dans de nombreux pays, mais il faut tout de suite souligner un point important, c'est que cette neutralité est très souvent déduite en réalité de plusieurs dispositions constitutionnelles, toujours interprétées par les cours constitutionnelles et les cours suprêmes. Rares sont les États qui présentent de façon expresse la neutralité dans le texte constitutionnel. Alors, sur les 23 pays étudiés, 5 font figure d'exception. Cuba, Côte d'Ivoire, Mexique, Turquie, Sénégal, en ce qu'ils inscrivent expressis verbis tantôt la sécularité, c'est le cas de la constitution mexicaine, cubaine et turque, tantôt la laïcité, ce sont le cas des constitutions sénégalaises et ivoiriennes. Et d'ailleurs, pour la constitution ivoirienne, le professeur à l'université d'Abidjan, Francisco Meledge, montre très très bien la constitution ivoirienne de 2016, réformée récemment en 2020, a inscrit la laïcité comme étant un élément insusceptible de réforme constitutionnelle. Mais tout ça pour dire que cette référence à la neutralité de l'État, soit implicite ou explicite, les pays étudiés ont cette neutralité en commun, même si je vais ensuite montrer que cette neutralité en commun est adaptée selon les histoires de chaque pays et qu'en réalité, sur la base de cette neutralité commune, ce sont des tolérances plurielles qui se manifestent dans beaucoup d'États. Cette neutralité en commun, tout d'abord. Alors en Allemagne, comme l'a relevé avec force Eva Loos dans son rapport, en Allemagne, il est très bien démontré que la neutralité de l'État est la seule approche possible, selon Eva Loos, afin de garantir une société pluraliste, justement, et ouverte, et de considérer que cette obligation découle de plusieurs dispositions de la loi fondamentale allemande. D'une manière générale, cette loi est de façon récurrente, cette obligation de neutralité est de façon récurrente mise en avant dans la jurisprudence de la Cour constitutionnelle allemande et des juridictions administratives. Toujours dans cette approche, il est intéressant de souligner la singularité belge. Pourquoi? Ce pays est très connu des comparatistes pour être un pays qui ne crée pas de frontières entre le national et l'international. Et à cet égard, Catherine van der Eyning explique très bien dans ce rapport que la neutralité de l'État est analysée toujours à l'aune de l'article 19 de la Constitution qui protège la liberté de religion, mais à la lumière également de l'article 9 de la Convention européenne des droits de l'homme. Et donc, c'est une analyse combinée de la neutralité de l'État à travers ces deux dispositions, une disposition nationale et une disposition conventionnelle, que l'approche neutre est appréhendée. Alors, dans d'autres États, c'est intéressant parce que beaucoup de préambules de constitution mentionnent quand même Dieu. Mais bien que le préambule fasse référence à Dieu, selon les rapporteurs, cela n'a pas de conséquences importantes sur le rapport de l'État aux religions. D'abord parce que très souvent, pas toujours, mais très souvent, le préambule ne fait pas partie de la Constitution et n'est pas, par définition, mais n'est pas considéré comme contraignant, est considéré comme une dead letter, pour reprendre une expression utilisée dans le rapport canadien. Mais surtout, pour les rapporteurs nationaux, cela n'engendre aucun biais spécifique du rapport de l'État à la neutralité. Ainsi, en Australie, les professeurs Cheryl Sanders et Tom Daly démontrent très bien qu'en dépit du fait que le préambule, qui n'a pas de valeur juridique comme tel dans le système constitutionnel, fasse référence au Almighty God, l'article 116 de la Constitution permet en réalité d'affirmer que l'État est neutre. Il en va de même exactement au Brésil, puisque le préambule dispose que la Constitution a été promulguée sous la protection de Dieu, mais la majorité des juristes, comme le relève Carlos Lima dans son rapport, ne le considèrent pas comme étant une norme contraignante. Et surtout, cette référence à Dieu est plus vue comme une référence d'ordre culturel que comme une référence d'ordre juridique. Et la même conclusion a été faite dans le cas sud-africain par le rapporteur Anton Kok, leur professeur Anton Kok, qui considère que les références à Dieu dans le préambule de la Constitution font certainement référence au Dieu chrétien, mais n'induit aucun biais, selon lui, dans l'analyse de la neutralité de l'État. Dans la même veine, le Canada est sur cette même approche, comme l'a très bien montré aussi le rapporteur Faisal Baba, puisque au Canada, le préambule est considéré comme une dead letter, et donc la référence à Dieu dans ce préambule n'a pas d'importance outre mesure. Il reste que, et c'est très intéressant, sur les 23 États étudiés, l'ordre juridique de 2 d'entre eux est très ambigu. Il impose d'importantes ambiguïtés sur le rapport de l'État à la religion et ce faisant donc à la neutralité de l'État à l'égard de toutes les religions. Ces exemples, ces États sont les suivants: les États-Unis d'Amérique d'un côté et la Tunisie de l'autre. Les États-Unis d'Amérique ont bâti un rapport à la religion qui découle de la jurisprudence de la Cour suprême qui, très tôt, dans les années 40-47, a affirmé la neutralité de l'État à l'égard de la religion. Mais Christoph Henkel, avec brio dans son rapport, montre, dans un rapport extrêmement critique, je dois le souligner, à l'égard des États-Unis, montre que cette neutralité de l'État construite par la jurisprudence de la Cour suprême a été détricotée ces 20 dernières années sur la base d'une guerre culturelle extrêmement puissante, forte, qui oppose les partisans conservateurs et démocrates et qui a induit beaucoup de nuances, de limites, de restrictions à cette neutralité de l'État affichée dans la jurisprudence de la Cour suprême de ces dernières années. Quant à la Tunisie, le professeur et juge à la Cour africaine des droits de l'homme, Rafa Benachour, montre très bien que la nouvelle constitution de 2014, adoptée dans la mouvance du printemps arabe, eh bien, a établi un rapport extrêmement ambigu à l'islam et qu'en réalité, l'islam structure non seulement la constitution tunisienne, mais structure les rapports de force au sein du pays et il considère cette ambiguïté assez dommageable pour la pacification des relations politiques en Tunisie. Alors, en dépit, vous le voyez déjà, des nuances que j'ai pu apporter dans le cadre de cette fondation commune qui est la neutralité de l'État, je vais encore aller plus loin dans les nuances puisque la tolérance des pays à l'égard justement des manifestations religieuses sont importantes et à côté de cette neutralité de l'État, les tolérances plurielles sont assez imposantes. Quelques exemples suffisent à montrer qu'à partir d'une notion commune, donc neutralité, sécularité, laïcité, les approches pratiques sont très différentes, à l'égard essentiellement, vous l'avez compris, des manifestations extérieures, des convictions religieuses dans l'espace public, soit par des fonctionnaires, soit par des individus et des citoyens lambda. Et ici, il est très intéressant de voir que c'est tantôt l'existence avérée de sociétés multiculturelles qui sous-tend des solutions judiciaires très différentes, comme en Belgique, au Canada ou en Afrique du Sud. Tantôt, c'est une vision de la tolérance développée par le juge qui va embrasser de nouveaux mouvements multiculturels dans des sociétés qui, antérieurement, étaient plutôt ethniquement ou religieusement homogènes. Et enfin, l'existence d'une religion dominante, sociologiquement, démontre très bien qu'en dépit d'une neutralité affichée de l'État, la puissance sociologique d'une religion dominante affecte en réalité, bien évidemment, au quotidien, mais aussi dans les décisions de justice, cette soi-disant neutralité. Alors, ce qui est très intéressant, c'est que quand on examine sur le premier point, tolérance et société multiculturelle, les rapports canadiens et africains du Sud, d'Afrique du Sud, il est très intéressant de voir que la neutralité implique de favoriser le multiculturalisme et notamment dans le champ religieux. Stéphane Boele-Woelki, le rapporteur du Canada francophone, s'insurge d'ailleurs contre une loi récente adoptée au Québec qui interdit à tout fonctionnaire public de manifester de façon extérieure ses convictions religieuses et il considère que ce n'est pas du tout conforme à l'histoire canadienne et fustige ce qu'il appelle la laïcité à la française. Dans le même sens, le rapporteur d'Afrique du Sud, M. Koch, montre très bien qu'il y va de l'histoire de l'Afrique du Sud qui explique que la neutralité de l'État doit embrasser le multiculturalisme, doit même encourager le multiculturalisme, notamment dans l'expression des convictions religieuses. Et on voit qu'on a tout à fait une autre approche en Belgique. En Belgique, c'est tout à fait l'inverse de ces deux approches. Au contraire, qui dit neutralité des fonctionnaires publics dans le cadre de leurs exercices. La neutralité implique la neutralité de l'État et des représentants de l'État en contact avec les membres du public. Et donc, il n'y a pas ici de promotion du multiculturalisme, notamment religieux. Et cette approche belge, même si nous n'avons pas de rapport français, est tout à fait en tune, adéquate avec l'approche française. Alors, s'agissant du deuxième point, tolérance et appréhension du multiculturalisme dans des sociétés qui, a priori, n'étaient pas multiculturelles historiquement, comme l'Allemagne, eh bien, il est très intéressant de voir que, ou la République tchèque, en Allemagne, en République tchèque, la neutralité de l'État implique une tolérance à l'égard de toutes les manifestations religieuses et que évalueuses comme Veronika Bilkova, dans leur rapport respectif Allemagne-République tchèque, montrent très bien la tolérance développée par les juridictions constitutionnelles et administratives à l'égard des manifestations extérieures de convictions religieuses. S'agissant de l'Espagne, Zoila Combalia et Jaime Rossell soulignent quant à eux qu'en réalité, la jurisprudence des tribunaux sera marquée constamment par une approche nuancée où chaque fait, chaque cause, chaque spécificité des affaires induit des solutions adaptées. Donc, il n'y a pas un grand principe qui va constamment irriguer les décisions. Il y a à chaque fois la volonté d'adapter en fonction des faits de l'espèce. Alors, il y a toujours la complexité qui surgit dans l'analyse, parce que quand on analyse tolérance et religion dominante, le cas de la Grèce est tout à fait symptomatique, puisque Alexandra Dunga et Vassili Kumpli ont très récemment, dans leur rapport, critiqué une décision récente du Conseil d'État grec qui valide un système particulier où, en réalité, en Grèce, tous les enfants qui ne relèvent pas de l'Église orthodoxe orientale du Christ, qui est la religion dominante en Grèce, qui est consacrée dans la Constitution, doivent présenter une dispense pour être dispensés des cours relatifs à cette religion. Et le Conseil d'État a validé l'exigence de cette dispense pour les enfants qui sont athées, qui ne sont pas reliés à cette religion. Les rapporteurs ont vivement critiqué cette jurisprudence en considérant que le Conseil d'État grec avait identifié à tort l'État à la religion et qu'il assimilait la conscience nationale à la conscience religieuse, ce qui était pour eux un grave défaut. Et d'ailleurs, cette approche est sous la contrainte de la Cour européenne, puisque la Cour européenne, dans un arrêt de Papa Georgiou et autres contre Grèce, d'octobre 2019, a sanctionné cette obligation de dispense pour les enfants qui ne relèvent pas de cette religion. Alors, neutralité de l'État, vous l'avez vu déjà avec beaucoup de nuances, qui se conjugue avec la centralité des droits. Les droits de la personne humaine, comme ceux des membres de certains groupes, constituent le cœur des édifices constitutionnels contemporains, on le sait. Mais même si leur mécanisme de protection prend des formes extrêmement différentes selon les cultures juridiques de chaque pays, leur centralité est vraiment indiscutable. Et comme l'a souligné tout à l'heure le juge Vodicek, Christophe, ce sont les deux vecteurs de la dignité et de la non-discrimination qui impliquent de prohiber toute forme de différence non appropriée, qui irrigue vraiment le paysage de la protection des droits humains. Alors, ce qui est intéressant, c'est que nous avons pu observer les grandes divisions régulièrement sur certains points entre les pays de droit continental et les pays de common law. Dans les pays de droit continental, l'intégration d'un catalogue des droits et libertés est très souvent reliée à la dignité humaine, soit par la Constitution elle-même, c'est l'Allemagne, le Brésil, Cuba, l'Espagne, la République tchèque, le Mexique, le Pérou, soit par la jurisprudence constitutionnelle, par exemple, comme au Sénégal, ou encore en Italie, comme l'a démontré, ou en Mexique, pardon, comme l'a démontré Irene Spigno. Dans les pays de common law, en dépit d'une imposante hétérogénéité d'ordre technique, très imposante hétérogénéité d'ordre technique, les principes de dignité et d'égalité et donc de non-discrimination sont également présents dans tous les schémas constitutionnels et législatifs, mais je dois dire souvent plus législatifs que constitutionnels. Et en réalité, ça découle plutôt de la loi et d'accords politiques trouvés après de nombreuses discussions plutôt que de la Constitution. Alors, une exception, c'est le Canada, puisque Fassai Beba, là aussi, dans son rapport, montre très bien que l'intégration de la Charte des droits et libertés au sein de la loi constitutionnelle de 1982 est de façon exceptionnelle dans le monde anglo-saxon, révélatrice d'un mouvement de constitutionnalisation des droits et libertés, mais ce qui n'est pas forcément le point commun dans les pays de common law. Ceci établi, quel en est-il du droit des minorités nationales, sexuelles ou encore raciales? Comme l'a dit Christophe, les thèmes abordés étaient majeurs. On a essayé de prendre en compte tous les points, mais ce n'est pas évident. Alors, aujourd'hui, pour cette présentation, je parlerai des questions des minorités sexuelles sur ce point, parce que les évolutions sont absolument emblématiques, puis ce sera un lien que j'opérerai avec l'introduction générale si brillamment présentée tout à l'heure par l'ancien juge de la Cour suprême d'Afrique du Sud. Quelques mots donc sur ces deux éléments, surtout sur la question des minorités sexuelles. En Allemagne, ce qui est absolument frappant, c'est que l'importance du libre épanouissement de la personnalité, associé à d'autres principes constitutionnels, a permis des évolutions impressionnantes. Eva Loos présente une décision rendue en 2017 par la Cour constitutionnelle allemande sur le troisième genre. Et la Cour constitutionnelle allemande a fustigé l'obligation posée par l'administration allemande de devoir absolument, quand on est un individu, s'identifier de façon binaire, soit homme, soit femme. Et la Cour constitutionnelle allemande, donc dans cette décision de 2017, troisième genre, a considéré que c'était un fardeau excessif et qu'il fallait laisser aux individus leur droit à l'auto-identification, notamment quand une personne ne se reconnaît pas dans un de ces deux genres. La même chose au Mexique. L'évolution de la jurisprudence sur les droits des homosexuels, mais également les droits des personnes transgenres, est absolument incroyable. Et là, je rajouterai un point, notamment aussi, chose que l'on ne voit pas dans les rapports des pays de common law, grâce à la jurisprudence de la Cour interaméricaine des droits de l'homme, qui, sur ces questions, est proprement très progressiste. Et toutes les réformes constitutionnelles législatives au Mexique ont été adoptées notamment à la suite de l'avis très important numéro 24 de la Cour interaméricaine rendu en 2006 sur les couples de même sexe. Et donc, au Mexique, aujourd'hui, 13 États fédérés sur 32 ont d'ores et déjà lancé des réformes de leur code civil pour prendre en compte les questions de genre et notamment le troisième genre. Alors, s'agissant des communautés autochtones, puisqu'il n'y a pas cette analyse n'est pas centrée uniquement sur les minorités sexuelles. S'agissant des communautés autochtones et religieuses, il y a des différences très importantes entre les grandes familles juridiques mentionnées. Quelques éléments. La question de l'auto-identification des communautés autochtones comme des communautés religieuses n'engendre aucun débat entre les pays de common law et les pays de droit continental. Là, ils sont tous sur la même longueur d'onde. Les communautés autochtones comme les communautés religieuses ont le droit de s'auto-identifier selon leurs propres critères. En revanche, et là c'est tout à fait intéressant, s'agissant de leur pouvoir d'auto-organisation des communautés autochtones et des communautés religieuses, participation au débat public et à l'élaboration des législations, là le divide entre le monde continental et le monde anglo-saxon est majeur. Quand on examine d'un côté le rapport australien très intéressant de Sheryl Sanders et de Tom Daly, on se rend compte à quel point, en dépit de grands débats politiques qui transpercent la société australienne depuis plus de 20 ans, les communautés aborigènes n'ont toujours pas aujourd'hui la capacité de participer à l'élaboration des législations qui ont à voir avec leurs intérêts et leurs droits. C'est toujours en discussion. Alors, quand on examine les pays du continent sud-américain où des communautés autochtones existent, comme évidemment au Pérou, au Mexique, au Brésil, on est loin de cette approche encore très restrictive, puisque non seulement le fait autochtone est intégré dans les constitutions, mais que le fait autochtone est également reconnu, bien évidemment, à l'échelle de la jurisprudence de la Cour interaméricaine, qui est donc un aiguillon extraordinaire pour réellement transformer d'en haut, de l'extérieur, la pratique. Donc là, vraiment, le divide est très, très important en la matière. Voilà. Donc, au terme de la présentation de cette première partie, car j'ai peur d'être un peu trop longue, ça va, d'accord, qui entendait mettre en valeur les deux piliers des libéraux des sociétés contemporaines, la neutralité de l'État et la centralité des droits humains, mais aussi des droits des groupes. L'éloge de la nuance, pour ne pas dire l'éloge de la complexité, était déjà au rendez-vous, vous l'avez compris. Mais cet élément est particulièrement renforcé quand on découvre qu'en dépit de la force symbolique et juridique de ces deux grands piliers, une multitude de contraintes socio-historiques continuent de peser sur les ordres juridiques contemporains. Le poids de l'histoire permet d'expliquer l'existence d'importantes différences dans l'existence ou non d'une pluralité d'ordres juridiques, par exemple, au sein des structures constitutionnelles des États, dans la vision globale de la démocratie, ou encore dans l'importance du poids accordé à une religion spécifique. Si cet élément n'a rien de surprenant, et je vais décliner quelques éléments connus ou moins connus, ce qui l'est plus en revanche, c'est de constater qu'en dépit de l'adoption de constitutions aux valeurs libérales, en dépit de la valorisation des droits individuels et collectifs, certains États sont toujours fortement attachés à leurs us et coutumes. Parfois, ces us et coutumes sont en totale harmonie avec les valeurs libérales, parfois non, et c'est ce qui est assez perturbant, mais c'est ce qui permet aussi de prendre la mesure du réel au-delà du formalisme juridique. Toujours mettre les choses en contexte, c'est très important. Alors, quelques mots sur le poids de l'histoire. Ici, nous avons distingué deux épreuves, c'est le mot important, historiques. D'un côté, la colonisation, et puis de l'autre, pêle-mêle, si je puis dire, la dictature, les guerres, les régimes autoritaires, les révolutions. Bref, autant d'éléments violents qui ont marqué à un moment donné l'histoire des pays et qui continuent aujourd'hui, dans le présent, d'agir. Quelques mots sur le poids de la colonisation. Alors, ce poids est évidemment majeur à l'égard des groupes colonisés et des groupes qui ont été mis en esclavage. Et sur ce sujet, je dois dire que le constat est édifiant, pour ne pas dire assez désespérant, que le pays étudié soit un État démocratique, qu'il soit développé ou pas, qu'il fasse partie du Global North ou du Global South, le constat est le même. Les communautés autochtones qui ont subi la colonisation, les communautés ou les groupes qui ont été mis en esclavage, sont toujours sont toujours victimes de discrimination systématique. Et cette sombre réalité ne peut pas être niée, elle fait régulièrement surface et tous les rapports, et je dois souligner que je dois remercier les rapporteurs nationaux pour leur franchise et leur objectivité, tous les rapports le démontrent. Le rapport sur les États-Unis, Black Lives Matter, le rapport sur le Brésil, où le rapporteur Carlos Lima met en avant un arrêt très important de la Cour interaméricaine, Brasil Hacienda Verde, qui démontre qu'encore aujourd'hui, en 2021, des membres de la communauté afro-descendante sont mis en esclavage pour travailler dans les grandes haciendas. Le rapport canadien qui démontre qu'il a fallu attendre 2015 pour qu'une commission vérité et réconciliation soit mise en place au Canada pour que la question des peuples autochtones martyrisés par l'histoire canadienne puisse être discutée sans tabou. Et évidemment aussi le long processus politique en Australie qui ne cesse d'évoluer au gré des conjonctions conservatrices ou des plus progressistes des gouvernements. Donc, comme par exemple en Australie, rien n'est figé dans la Constitution, État fédéral, un État extrêmement complexe de common law, où le niveau fédéral entrechoque le niveau fédéré et où en réalité tout se joue en termes de négociations politiques, le rapport met très bien en évidence qu'à partir du moment où certains éléments sont acquis, mais qu'un gouvernement conservateur prend le pouvoir, il peut détricoter par la loi ce que l'ancien avait aussi bâti. Et d'où l'intérêt, quand même, parfois peut-être, d'avoir des fondements constitutionnels plus importants. Alors ça, ce poids de la colonisation apparaît à l'égard de ces groupes discriminés, elle apparaît aussi au regard de la place des religions. Il y a, dans certains pays, en dépit de l'affichage libéral, en dépit de l'affichage de neutralité de l'État, des pays où la religion du colonisateur, comme au Pérou ou comme au Canada, est dominante sociologiquement et elle ne cesse d'impacter les décisions soit de justice, soit les décisions politiques. Le rapport sur le Pérou de César Landa est à cet égard incroyable puisqu'il montre très bien que sur les questions relatives à la pilule et l'avortement d'urgence ou encore le mariage homosexuel, la hiérarchie catholique est intervenue directement dans les débats et a fait pression sur les juges constitutionnels pour qu'ils n'adoptent pas d'approche trop progressiste. Et le tribunal constitutionnel du Pérou récemment a présenté des décisions extrêmement restrictives en la matière. Alors, l'autre point, à côté de la force de la colonisation, c'est le poids de la guerre. Comme je vous l'ai dit, en appréhendant ce terme de façon très large, incluant les soubresauts des révolutions, les dictatures, les régimes autoritaires. Et le poids de la guerre influe sur certains éléments, soit sur la vision de la démocratie, soit sur le fonctionnement de la structure constitutionnelle des États. Et c'est très intéressant. Sur le premier point, par exemple, sur la vision de la démocratie. Quand un État a vécu le totalitarisme, il veut échapper évidemment à son inlassable répétition. Du coup, c'est la notion de démocratie militante qui l'emporte, comme en Allemagne, par exemple, ou comme en République tchèque, ou comme au Pérou, où, pour préserver les valeurs libérales et pour ne plus retomber dans ce qu'on pourrait qualifier rapidement l'horreur, eh bien, il y a certains éléments qui ne doivent pas être atteints et les constitutions s'engagent pour préserver coûte que coûte l'ordre libéral et démocratique en restreignant par ailleurs certains droits, limites au pluralisme au nom de la démocratie militante et du fait d'une histoire douloureuse. De même, quand un État a vécu une révolution singulière et qu'il y reste très attaché, comme évidemment cubain, eh bien, le rapport de Ernesto Morera Sardiñas met très bien en évidence que le socialisme, comme l'anti-impérialisme, continue aujourd'hui, en dépit d'une constitution récente, celle de 2019, eh bien, d'irriguer toute la rhétorique constitutionnelle. Le poids de la guerre a été aussi très important dans la structure et le fonctionnement constitutionnel de certains États et l'existence notamment d'ordres juridiques pluriels. Prenons le cas de la Grèce. Il y a un ordre juridique pluriel en Grèce où une communauté musulmane vit notamment en Thrace du fait des effets de la dislocation de l'Empire ottoman au XIXe siècle. Des suites de la dislocation de l'Empire ottoman, des traités internationaux ont été adoptés au début du XXe siècle et ces traités internationaux ont protégé la minorité musulmane en Grèce qui peut vivre selon les us et coutumes de la charia, la loi islamique. Mais pas à n'importe quel prix. Et dans une affaire très intéressante qui a été jugée par la Cour européenne, l'affaire Molla-Sali contre Grèce de 2018, la Cour a rappelé cette préservation d'une identité et d'une religion musulmane au sein d'un État orthodoxe vaut parfaitement du fait de la guerre. Mais attention, quand un membre de cette propre minorité musulmane ne veut pas appliquer les règles de la charia et veut appliquer les règles de droit commun propres au droit civil, alors laissons-le le faire. Et l'arrêt Molla-Sali contre Grèce en la matière de 2018 est tout à fait exceptionnel. Et je terminerai, j'espère que j'ai encore quelques temps, il me reste 2 minutes, très bien, par le poids des traditions. Alors, qu'est-ce que met en évidence ici les rapports ? Pour aller vite. D'un côté, nous avons des traditions, des us et coutumes qui intègrent d'ailleurs la pluralité des ordres juridiques, comme en Côte d'Ivoire, qui se marient très bien avec le libéralisme contemporain. Le rapport de M. Meledge met très bien en évidence la résurrection des chefferies traditionnelles qui intègrent très bien le fonctionnement démocratique de l'État. En revanche, il y a des traditions plus régressives et je dois souligner la force du rapport de notre collègue japonais, Masako Kamiya, qui, avec puissance, engagement, a fortement critiqué les traditions régressives qui continuent à exister au Japon à l'égard des communautés autochtones au Japon, car il y a des communautés autochtones au Japon, mais c'est farouchement nié par le gouvernement japonais. Il y a aussi des approches régressives à l'égard des femmes, avec une vision très archaïque de la place et du rôle des femmes dans la société japonaise, et aussi il y a une vision régressive à l'égard des étrangers. Et ça, le rapport de notre collègue japonais le met très bien en évidence. Alors, ce qui est étonnant, c'est qu'au Pakistan, il y a aussi des us et coutumes qui permettent de valoriser les musulmans au détriment des autres minorités. Et donc, il y a quelques traditions aussi qui choquent les valeurs libérales de la société pourtant affirmées. Mais le rapport de notre collègue Assad montre ici que, contrairement au Japon, eh bien, les valeurs libérales de non-discrimination sont défendues par le système judiciaire pakistanais, à l'inverse du système japonais, où, là, pour le coup, chose étonnante, les juridictions japonaises ne jouent pas le jeu de la protection des valeurs libérales. Et en une minute, vraiment, je finirai par quelques propos conclusifs. Premièrement, les 23 États étudiés plus les 2 systèmes transnationaux analysés montrent quand même la puissance, à tout le moins juridique formelle, des valeurs du libéralisme politique. Dans le cadre du constitutionnalisme contemporain, c'est indéniable. Mais au-delà de ce constat, ce qui est impactant, c'est évidemment la force de l'histoire avec tous ses ravages et sa présence dans le présent, mais aussi l'extraordinaire summa divisio entre pays de common law et pays de droit continental. Je ne pensais pas que cette summa divisio était encore si puissante dans le champ des droits humains. Et ce qui fait la différence, c'est 2 points. C'est que les pays de common law vivent en vase clos. En termes de décisions de justice, les décisions de justice ne fonctionnent qu'entre pays de common law. Beaucoup de ces pays de common law ne sont pas sous la juridiction d'une cour régionale de protection des droits. Et on voit les effets de l'absence d'une cour régionale de protection des droits parce que le droit international en tant que tel n'est pas si puissant dans ces pays que dans les pays de droit continental, qui en plus se retrouvent sous la juridiction d'une cour régionale, la Cour européenne, la Cour interaméricaine ou la Cour africaine. Alors ça, c'est vraiment tout à fait saillant. Et en découvrant les 2 rapports transnationaux, je dois dire que cela apparaît de façon encore plus flagrante. Et le rapport notamment de Sergio García Ramírez, ancien président de la Cour interaméricaine des droits de l'homme, démontre très bien, en prenant le point de vue de la Cour interaméricaine, à quel point sa jurisprudence a infusé les pays du continent et a participé à être un élément transformateur. Et le rapport équivalent pour l'Europe le démontre aussi. Donc, ce sont les conclusions transversales, si je puis dire, de l'analyse de ces 23 rapports nationaux. Merci encore pour votre attention.
Thank you very much. I think we are back live. Thank you for staying in with us. So just taking also the opportunity to acknowledge the incredible help of the logistics here. That is amazing what is being done so that we can be here for you in Pretoria and also obviously abroad for this first hybrid Congress of the Academy. So, well, first of all, thank you very much, Laurence, and obviously Christoph, for this first general presentation of this general report, which we're so happy to discover together. So we do have a bit of time for some questions. I must say questions, these seem to be very difficult to answer in a few minutes, but there are some themes that were brought up and raised definitely some interest. And first, perhaps, let me get back to what you just concluded with, which is the divide between civil law and common law. So perhaps you'd like to elaborate on that both, as there seems to be specifically an interest in that, and maybe also particularly on that point that the absence of a regional court seems to also have a huge impact on then the question of a possible homogeneity in terms of solutions.
Merci. Si tu le veux bien, Christophe, je démarre. Et puis, si tu as quelque chose à ajouter, je serai heureuse de pouvoir t'écouter. Ça a été vraiment une conclusion importante, étonnante parce que je pensais, comme je l'ai dit à l'instant, que dans le champ des droits humains, cette summa divisio entre les grandes familles juridiques allait quand même exploser, justement grâce à la circulation des décisions de justice. Et la circulation des décisions de justice, même si c'est un phénomène, et nous en avons parlé juste dans le panel précédent, est un phénomène global, connu, parfois critiqué. Cette circulation, elle ne prend pas les mêmes atours en fonction des grandes familles juridiques. Et il est très intéressant de voir que dans tous les pays de common law analysés, le Canada, l'Afrique du Sud, l'Australie, ils mettent en avant les influences réciproques que les juridictions de ces pays ont pu avoir. Donc là, la circulation des décisions de justice fonctionne, mais dans ce que j'ai appelé cette bulle de common law. Donc, ça crée un monde à part qui dérive de l'histoire, évidemment. On ne peut pas faire fi de l'histoire comme ça. Et les références, dans le cadre de ce phénomène de circulation des décisions de justice, les références à des décisions de justice de pays de droit continental sont quasi absentes. Et alors, plus étonnant, des références aux grandes décisions des cours régionales sont également absentes. Je m'étais dit en européenne et en française que la jurisprudence de la Cour européenne des droits de l'homme, par exemple, avait quand même acquis de nos jours une force étonnante et avait peut-être même remplacé celle de la Cour suprême américaine. Mais je me suis rendu compte que dans l'univers de la common law, elle était méconnue, en tout cas à travers les rapports que j'ai pu lire. Donc ça, c'est le premier point. Et en contrepartie, justement, la puissance réformatrice des jurisprudences régionales, européennes, africaines et interaméricaines est majeure. Et en lisant les rapports nationaux, en lisant les 2 rapports supranationaux, c'est absolument flagrant. Et là, si je peux me permettre un point de vue plus personnel, puisque j'ai dû rester un peu plus objectif dans l'analyse des rapports, mais je considère objectivement, en ayant eu sous les yeux toutes ces analyses, que la puissance des jurisprudences régionales est telle qu'elle accélère les transformations juridiques. Je ne dis pas que ces transformations juridiques sur les communautés autochtones ou sur les minorités sexuelles ou les communautés religieuses n'existent pas dans les pays de common law, bien évidemment, mais les acquis sont plus lents et sont aussi susceptibles de négociations politiques qui risquent de tout faire déliter. J'ai en mémoire une phrase du rapport canadien francophone présenté par M. Boele-Woelki, et il dit très clairement que le droit international dans le champ de l'ordre juridique canadien francophone n'a pratiquement aucune influence. Et c'est aussi très intéressant de voir que le rapport canadien, parce que je l'ai bien en tête, anglophone et francophone, ne font à aucun moment, par exemple, référence à la doctrine de la Commission interaméricaine qui pourtant s'applique dans leur pays. La Commission interaméricaine a rendu un rapport incroyable sur les meurtres systématiques des populations autochtones au Canada anglophone. Bon, ça n'apparaît pas dans le rapport national. Cela montre que ce n'est pas un élément d'analyse dans le champ même universitaire. Donc, il y a, je pense, encore beaucoup à faire pour participer à réunir les 2 mondes. Vraiment, encore, droit civil, common law, et échanger avec ouverture d'esprit sur nos systèmes juridiques avec leurs défauts et leurs points forts, mais pour améliorer et diminuer le gap entre ces 2 grandes familles juridiques.
Merci beaucoup, Laurence. Christoph, perhaps you would like to jump in?
This triggers an additional remark. The common law jurisdiction operate nonetheless under the supervision of the global United Nations system of human rights protection. So some of them have accepted the right of individual application to the treaty bodies. But this shows that the global system is maybe less efficient than the regional systems, especially in terms of enforcement. But still, we had a few examples, maybe in which the global system has, to a certain extent, influenced certain judicial decisions in the common law countries. So I would be a little more nuanced on this point, although I agree with the general point of view expressed by Laurence. Thank you.
Thank you very much. I think we can see that we still have a bit of time, so it's good that we can get to the second question. And believe me, it is not an easy question. I might switch to French as it has been asked in French. C'est la question du lien entre, d'une part, la reconnaissance de la diversité et la pluralité en droit et le concept d'activisme juridique. Donc, ce n'est pas vraiment une question, c'est plus un sujet de dissertation peut-être. Mais peut-être que vous avez quelques observations tous les deux sur ce sujet.
Merci Alexandre. Alors, spontanément et aussi au regard de ce que nous avons pu découvrir dans les rapports, ce qui est très intéressant de voir, c'est que toutes les conquêtes progressistes en matière de reconnaissance des droits des minorités sexuelles ou aussi en matière de reconnaissance des droits des communautés autochtones, ce qui transparaît des rapports nationaux, c'est que ces conquêtes ont eu lieu grâce à une évolution judiciaire, juridictionnelle, législative qui est inférée notamment des cours régionales, mais évidemment pas que. Et qu'à la base de ces évolutions progressistes, il y a toujours eu des mouvements activistes. Je regarde mon amie Aïda qui est en face de moi, je pense évidemment à l'Argentine, puisque la dernière bataille des droits des femmes en Argentine n'a pas pu avoir lieu et ne s'est pas réalisée sans l'engagement, l'activisme, le courage des femmes argentines pour obtenir la loi sur l'avortement. On voit exactement la même chose au Mexique avec les droits des minorités sexuelles et aussi les droits des communautés autochtones. C'est qu'à un moment donné, il y a eu la volonté politique de ces groupes-là de se lancer dans la bataille politique pour faire avancer les choses. Et de là, combiné avec une ouverture progressiste de certaines juridictions, cela a amené les éléments transformateurs par des décisions de justice et ou par des décisions politiques. Mais ce qui est certain, c'est que sans activisme juridique, les évolutions n'auraient peut-être pas eu lieu ou auraient eu lieu avec beaucoup plus de lenteur ou avec des résultats moindres. Donc, l'activisme juridique est consubstantiel aux conquêtes en matière de droits humains.
Christophe, est-ce que vous souhaitez intervenir sur cette notion d'activisme juridique?
C'est un peu difficile de commenter, mais je pense que tout de même, dans beaucoup de domaines, l'impulsion vient du législateur national. Il n'y a pas que le juge qui intervient. Il y a aussi le législateur national qui intervient et qui induit des changements importants. Donc, les rôles sont partagés. Je serai un peu plus nuancé sur le rôle du juge. Il y a eu beaucoup d'évolutions qui ont été initiées non pas par les juridictions constitutionnelles ou suprêmes nationales ou internationales, mais par les parlements nationaux. Il ne faut pas non plus sous-estimer le rôle du Parlement national dans ce domaine.
Alors en fait, si je peux, peut-être que je me suis mal exprimée, mais où c'est intéressant parce que j'aurais dû peut-être commencer en disant qu'est-ce qu'on entend par activisme juridique et d'où vient-il? Dans mon esprit, je parlais de l'activisme juridique de la société civile. Donc la société civile, les mouvements de la société civile ont été constamment à la manœuvre, si je puis dire, pour faire avancer le droit, soit, comme tu l'as dit, Christophe, en faisant pression sur le législateur, soit en tentant des strategic litigation dans le but d'obtenir des changements de jurisprudence. Je pense, par exemple, à l'affaire Maria do Peña contre Brésil, une affaire traitée par la Commission interaméricaine. C'est tout à fait un exemple de strategic litigation activé venant de la société civile. Voilà que cette femme battue régulièrement pendant 20 ans par son mari, c'était un exemple de violence faite aux femmes, a été laissée pour morte plusieurs fois. Son cas a été jugé emblématique par les associations de la société civile en Amérique latine, notamment la grande ONG Cérémonie, Centre pour la justice et le droit international, et une grande ONG de défense des droits des femmes, CLADEM. Et ces deux grandes ONG ont été voir Madame da Peña, lui ont demandé si elle voulait bien être au cœur d'une contentieux stratégique pour faire changer entièrement le droit en la matière au Brésil. Elle a accepté et son affaire a permis l'adoption d'une loi dite Maria da Peña qui met fin aux violences systématiques faites aux femmes, enfin qui met fin juridiquement aux violences systématiques faites aux femmes. Et donc, c'est cet aspect-là que je voulais mettre en évidence. La puissance de la société civile pour les conquêtes des droits. Et là, après, le juge et aussi le législateur peuvent prendre à bras le corps ces revendications pour les intégrer ou pas, bien sûr. Mais l'exemple de la loi Maria da Penha au Brésil est très connu et emblématique de ça, je pense.
Alors, effectivement, nous n'allons pas pouvoir savoir quelle était effectivement la définition qu'avait la personne qui a posé la question du concept d'activisme juridique. Est-ce qu'on faisait peut-être référence aussi à une certaine revendication du juge, à un agenda, ou en tout cas de vraiment assumer le fait de peut-être avancer, comme on dit en anglais, advance rights and protection. Mais peut-être vu qu'il nous reste 6 minutes, and I will try to switch, or I will switch to English for the last question. I see that there's a question on the dialogue between judges. And perhaps we may extend it now, following up on the remark by Christoph, the dialogue not just between judges. So here the question refers obviously to the Supreme Courts, the constitutional courts, and the international courts, or regional courts in our case. But we may extend it also to the dialogue perhaps between legislators. So perhaps you'd like to give us some concluding remarks on this possible dialogue and circulation of ideas, solutions, case law in this regard.
Christophe, est-ce que tu veux démarrer sur cette question?
Well, first and foremost, I think that there is a dialogue between legal professionals all over the world. Academics, politicians, lawyers, those who are involved in NGOs. And I think this is the most important forum for the promotion of new ideas. And then from this global forum, ideas spread to international courts, to domestic legislatures, and so on. Now, there is a very interesting phenomenon that we have a regional conversation within the English-speaking world among the common law jurisdictions, who quote each other, then the courts look at what happens in other common law countries, whereas they overlook what may happen in non-common law countries. In continental jurisdiction, it's quite different because they are much less open on comparative law arguments. They quote less frequently case law from other countries, yet from time to time they do this. This may play an important role for certain judicial decision, but at the same time, they seem to be much more open on this dialogue with international judges and international treaty bodies. So the way the idea is circulating the two legal systems, legal families, I confirm, not exactly the same.
Oui, merci Christophe. Alors moi, je rajouterais que, mais dans le prolongement de ce que tu as dit, le dialogue entre les juges est un phénomène évidemment fascinant et il se manifeste de plusieurs manières, à travers des décisions de justice. Cet élément a été énormément étudié par la doctrine dans le monde entier, qu'elle soit anglo-saxonne ou pas. Il y a un autre élément que moi j'appelle la diplomatie judiciaire, qui est fascinant à découvrir, qui est quand des conférences entières de juges constitutionnels, francophones, anglophones, de juges internationaux, des juridictions de protection des droits de l'homme ou des juridictions d'intégration économique se rencontrent et discutent. Donc, ces forums, ces grandes conférences qui permettent aux juges de se rencontrer, de discuter de problèmes communs de façon informelle, cette diplomatie judiciaire, elle est absolument majeure pour échanger des informations. Bien sûr, c'est avant tout ça, savoir et comprendre comment des juges placés dans des mêmes situations ont pensé la décision de justice. Et puis, c'est aussi assez fabuleux de voir à quel point il y a aussi d'autres manières où juges nationaux et juges internationaux peuvent interagir. Et là, je pense aux deux modèles mis en place par la Cour européenne d'un côté et la Cour interaméricaine de l'autre. la Cour européenne pour discuter sous forme de diplomatie judiciaire avec les juges constitutionnels nationaux, les fait venir une fois par an à Strasbourg lors de la rentrée solennelle. Et donc, tous les membres des juridictions constitutionnelles sont présents, écoutent une intervention générale, mais évidemment ensuite au déjeuner, dans les couloirs, juges constitutionnels, juges internationaux discutent parfois de sujets très sensibles, de tel ou tel arrêt qui a été mal reçu dans tel ou tel pays. Ça, c'est très, très intéressant, cette diplomatie judiciaire-là en Europe. En Amérique latine, c'est différent. Au regard des tas de conditions et d'ordre financier, d'ordre logistique, c'est la Cour interaméricaine qui se déplace. Et elle organise de temps à autre des sessions extérieures. Et lors de ces sessions extérieures à Mexico, à Bogota, à Buenos Aires, voilà que les juges interaméricains, les juges internationaux entrent en contact avec les juges nationaux, mais pas que, avec la société civile. Donc la session extérieure est l'occasion de rencontrer tous les acteurs judiciaires, mais aussi ceux de la société civile. Et j'ai pu le constater de près. Et ce qui est très intéressant, c'est que les juges internationaux mouillent leur chemise, en ce sens qu'ils vont même faire des cours pendant ces sections extérieures à des étudiants, à des PhD students, pour expliquer leur jurisprudence, maintenir le lien. Donc là, c'est assez extraordinaire de voir cette diplomatie judiciaire in action de différentes manières, mais de façon très, très intéressante. Et pour peut-être ajouter aussi un mot, tu parlais à l'instant du dialogue politique aussi. Il n'y a pas que le dialogue judiciaire, c'est vrai. Il y a le dialogue entre les parlements nationaux. Et à l'intérieur des États constitués, il y a évidemment le pouvoir judiciaire, mais à l'intérieur des États, il y a des instances autonomes. Les National Human Rights Institutions, par exemple, les commissions des droits de l'homme. Et ces commissions des droits de l'homme discutent aussi entre elles de façon transversale. Et ce sont des aiguillons très, très importants qui, de l'intérieur, peuvent interagir avec le législateur et aussi parfois les membres du pouvoir judiciaire. Voilà ce que je voulais dire en quelques mots, en complément de ce qu'a dit Christophe.
Mais merci beaucoup à vous deux. Je vois qu'il est 4 heures, donc il faut maintenant pour nous mettre un terme à cette passionnante session. Je crois qu'il nous reste évidemment 2 points et c'est premièrement une attente. Ce sera l'ouvrage qui sera publié à la suite de ce congrès et nous l'attendons donc évidemment avec grande impatience et nous remercions évidemment donc les 2 rapporteurs généraux et les rapporteurs spéciaux. Oui. Et il nous reste encore une chose, une certitude, c'est la place cruciale et l'importance du droit comparé quand on parle justement des droits humains. Je vous remercie et nous allons continuer dans 15 minutes avec le débat pour terminer cette première journée. Merci beaucoup.
Good afternoon, good evening, good morning. Sanibonani, Ruperile, Absheni, Macheroni. Ladies and gentlemen, you're joining us live at the University of Pretoria, the Law Auditorium, as we host the International Academy of Comparative Law. My name is Charles Maimel. I'm the Deputy Dean of the Faculty of Law, and I'll be chairing this session. Ladies and gentlemen, as chair of this debate, it's my singular honor to share the platform with Professor Christa Rothenbach from the University of Northwest, as well as Professor Gerbel from Singapore, who is joining us online. This affirms the hybrid nature of this conference due to the dynamics of COVID-19. Without further ado, ladies and gentlemen, each panel member between Professor Rothenbach as well as Professor Bell, they'll be given 10 minutes each to deliver their introductory remarks with regards to the topic at hand, which deals with customary law and non-state orderings, celebrating diversity and plurality in law. As we know, the diversity of the South African population, among others, and as you heard, I strived to also greet in the various indigenous languages of the South African community. Without further ado, I'd like now to invite Professor Rothenbach to the podium to indulge us on this exciting and important topic. Professor Rothenbach.
Thank you very much, Charles. when Gary and I spoke about the topic and what we were tasked to do, we actually realized that there are quite a lot of commonalities between the legal history of his jurisdiction that he's going to discuss and my jurisdiction. So we have decided to focus a little bit on the history and then leave the debate for more recent questions. So another thing that I would like to mention is when I started with legal pluralism studies in the 1990s, it was not actually something that lawyers did. That was more reserved for social anthropologists and legal anthropology. So a lot of people frowned when I went overseas to tell them, well, I'm doing my research on legal pluralism. So much so that one of my colleagues, he died last year, and he was also a co-editor of the textbook on legal pluralism that we did. And I did the section on non-state orderings, religious legal systems. He was telling me I should actually drop it from the book because this is a pseudo law. So I actually stuck to my guns and I said, no, it's remaining. So let me just tell you a little about my point of departure when it gets to legal pluralism. And I follow more or less on a very loose level the clarification and explanation given by Griffith. So I make the distinguish between weak or official legal pluralism and deep and unofficial legal pluralism. So the weak legal pluralism would be state law pluralism. And in South Africa, that includes the common law, our Western component, and the customary law, our African component. And then deep legal pluralism or unofficial legal pluralism is that those non-state orderings. So in South Africa, that would be all the unrecognized religious legal systems such as Muslim law, Hindu law, and Jewish law. Now, if you look at the history of South Africa, for the first 2 centuries during Dutch rule, there wasn't really weak legal pluralism or official legal pluralism, although deep legal pluralism did exist, or unofficial legal pluralism. So the Dutch weren't very much into the laws of the communities that were in South Africa at that stage. They were only concerned with the fact that we have a refreshment station, and that is supposed to be for all the ships passing by. So they followed the 17th century Dutch law, at that moment, the Roman Dutch law of the province of Holland. So it was before codification in South Africa. So that law is still now the basis of South African law. When the English came, and with the second English occupation in 1806, they had the policy of the law remains as it is, but of course it was influenced over the years by means of English law. So our transplanted common law is now this mixture of English law and Roman Dutch law. And at first, no cognizance was taken of any customary laws that were on South African soil. But then from 1846, more or less, as the colonialists started moving inland and Britain began to expand their rule in the areas that they were ruling, they realized, well, we are now bumping into these traditional communities. They have their own laws, and it's really creating conflict. So very grudgingly, they started to recognize in the different colonies these customary laws, but that was always subject to, of course, repugnancy clauses. And then in 1910, with the unification of South Africa, and about 17 years later, we received the notorious Black Administration Act of 1927. And this act sort of had a common policy or a national policy for South Africa with regard to customary law. And that was then followed in 1988 with the Law of Evidence Amendment Act that said courts must take judicial notice of customary law when it is readily ascertainable, and it also had a repugnancy clause. So that was sort of the first development into official legal pluralism or state law pluralism. So we can say, I would say in the colonies, it started in the 1845 upward, and then in 1910, the Black Administration Act endorsed this state law pluralism. But of course, still no cognizance was taken of religious legal systems, and we had minority groups, Hindus, Muslims, and Jews in South Africa, but their laws didn't count at all. So what happened in 1994? We got a constitution, and this constitution endorsed legal pluralism even further, and it celebrated diversity. And it made provision, it recognized customary law, first of all. So there was no doubt anymore. Customary law must be recognized, and it must be in par and equal to the common law. So suddenly we have two legal systems, state endorsed, and these two legal systems were now subject to the values and the rights in the Constitution. So if both customary law or common law must be interpreted, it must be interpreted in terms of the constitutional values and rights. So what does it mean? We still have a basic law or a law of general application, and that is our common law, which is still this mixture of Roman Dutch law principles and English law, of course, adapted and developed by means of legislation and case law. And then we have a law of limited application, which is the African customary law. And why is it of limited application? It depends on rules when the one applies and the other one applies. So customary law is more of a personal nature. It applies only in certain circumstances. So that is my one problem with how customary law is treated. The courts is so focused on giving it equal status. There's no issue. It has equal status to common law, but it cannot be treated the same way as the common law. Because the common law is known, courts can take judicial notice of it. But customary law is an oral law. And courts cannot take judicial notice of it because it is not known to the courts. So evidence must be led. But we had a few decisions, MM versus MN, for example. It's just a constitutional court decision where Justice Schoeman said that customary law is must be judicially, it must take judicial notice of it. And because it is just as important as the common law. And I don't have a problem with that. But Justice Zondo, who gave the minority decision, said you cannot say that. Customary law is a matter of fact. So there must be evidence before the court looks at the evidence, and from that then it determines what those rules are. So even if it is treated differently by ascertaining its content, it doesn't mean that it has a lower status as the common law. Now, with regard to non-religious or non-state orderings, that is on a different footing. Those legal systems are recognized because of the fact that the Constitution recognizes religious freedom, equality, and also has a section 15 in it that says the state can give recognition to other religious legal systems or personal legal systems or other religious or personal family law systems based on culture and religion. So the recognition of those non-state orderings will happen in a different way than, for example, our two state laws, the customary law and the common law. And what's happening is the legislator has been slow in giving recognition to those legal systems, and especially Muslim law. Although we have only a 2% minority in South Africa, they are quite adamant. They want their religious legal system recognized, especially in the context of family law. And it's been years since the first draft of Muslim marriage bill has been on the has been in Parliament, and that legislation has not been enacted yet. And there's been a number of decisions where the courts told the legislator, hurry up, get that legislation up, but they're not doing it. So what is happening now? courts are increasingly recognizing aspects of those religious legal systems, especially in the context of family law. So my argument is those non-state orderings are being celebrated, at least by our judiciary. And you get a number of examples. I've only got a few here in front of me. Let's get to them. My notes are almost as dear mekaar as Justice Cameron's this morning. But they are, for example, recognized as spouses in terms of the Interstate Succession Act. They're recognized as surviving spouses in terms of the Maintenance of Surviving Spouses Act. They are given a maintenance when they go to divorce courts. So even if their marriages are not recognized as valid marriages, the courts are interpreting, giving a very generous interpretation to legislation that speaks of spouses and families and children, to include the family members and the families of Muslim families, Hindu families, and they will even do it in the case of Jewish families. Or if it is a common law rule, they would develop that common law rule and say, well, even if the claim for a surviving spouse where a breadwinner was unlawfully killed by somebody else, which is a common law claim, even if that only referred to a common law marriage or a civil law marriage, we will expand that definition of spouse in terms of that common law rule to give Muslim spouses whose husband has been killed also a similar claim. And so my argument is that after 1994, our whole drive or our whole development with regard to legal pluralism is even expanding more and more. And that is quite an interesting way to look at legal pluralism, because I got the impression before 1994, everybody wanted to fit in. So they wanted to be categorized so that the common law could apply to them. But now that the Constitution is celebrating this diversity and this plurality of the South African population, it is expanding plurality more and more. It also creates difficulties because there's not always equality between those systems. And that is definitely something that we need to fork out and work out to reach a more just plurality in the South African society. Thank you.
Thank you very much. Thank you very much, Christa, for those insights. In a nutshell, Christa affirmed that in our diversity, we stand united.
Yes.
Professor Bell, your views, please.
To be with you, even if it's only virtually. I'm thank the organizers for inviting me. Let me say that I will, moi je vais parler en anglais ce soir, mais s'il y a quelques questions que ce soit, ça me fera plaisir d'y répondre en français. Christa and I have discussed this before, and we had a difficulty because we were asked to debate issues and we agree on everything. So it was very difficult to actually think of a debate. So what we thought of doing is we will present to you with some ideas which might be thought-provoking and hopefully debate-provoking. There's a few things that I would like to say. First of all, is that, of course, it might not be obvious to you, but I am not Indonesian. I stand in Singapore and I've studied Indonesian law for many years. I've been doing this for 25 years, but I am not Indonesian, and I almost feel like apologizing for that, because I would love to, in some way, to be Indonesian. It's a country I love and respect very much. There was a lot of talk today about legal plurality. And of course, we all recognize the plurality around the world, of course, of law. But what Christa and I are talking about is legal pluralism. The existence of different legal rules in the same territory. Whether these different rules are officially recognized or unofficial legal pluralism, the issue is really whether we do have and accept the presence of different rules, different laws in the same territory applying to different people. So if we recognize there's a plurality of law, if people have different cultures, different customs, and different religions, and these have legal consequences, should we not also recognize their right to follow their own law? Now, Indonesia is a legally pluralistic countries in many, many different ways, but to a large extent, it is official legal pluralism that we're talking about. But it's a very strange thing because it is technically a secular country. I'll come back to that a little bit later, but it does enforce religious Islamic law for the Muslims only, not for the others. So the legal pluralism that we have in Indonesia, the official legal pluralism, is a historical colonial legacy, also from the Dutch. So very many similarity with South Africa. But the Dutch remained in charge of Indonesia, what is today Indonesia, for longer, until 1945. Well, Dutch and then the Japanese until 1945. So what has happened is that the Dutch have actually done much more of legal pluralism in Indonesia. For example, at first, why did the Dutch have legal pluralism? Because they didn't care about the local law. They basically had legal pluralism because they cared about their own exploitation of the country and of its people. And to that, they applied Dutch law. But family law, inheritance law, and all these things that are local matters, they let them apply their own adat law, didn't care. But eventually, these local people came to the Dutch because the Dutch had the power to enforce laws, right? They were the colonial power. So eventually the Dutch created a separate court system, kind of a judicial apartheid, if you wish. They created a different court system for the locals in which the Dutch judges were applying whatever they understood of adat, which is customary laws, and of Islamic law. And they didn't like Islamic law very much, so they preferred to apply adat whenever possible, adat being the different adats, or the different customary law of Indonesia. The word adat is from Arabic, which means custom in Arabic. So the Dutch kind of transformed both the adat and the Islamic law a little bit to their liking or to their understanding. It became a Dutch kind of law. I mean, it was determined by precedents by Dutch courts. So it was kind of a weird system. And that's what Indonesia inherited at the time of independence in 1945. And it continued that system of official pluralism. And we therefore have Islamic law applied in limited fields of family law, inheritance, etc., and applied only to Muslims. This is similar in that respect to what we have in Singapore, which is a very modern state, but we do apply family Islamic law to Muslim. And it is a state that applies it in both Singapore and Indonesia. The courts are created by statute of the states. In Indonesia, they are state court. They go all the way, the religious Islamic court go all the way to the Court of Cassation, if you wish, in Kasasi in the Supreme Court of Indonesia. So the state has also given those courts, they train them, the judges, and then they give them a little book that's called the Compilation of Islamic Law. And the judges don't go to the normal sources of Islamic law, which is the Quran and the Sunnah. They just look at this book and apply it as if it were a code, which it is not. It's not a statute even. But what is the result of this? It gives you an application of Islamic law, which is really not entirely Islamic, if I may say so, right? The compilation, for example, effectively gives a right to divorce to women on demand, basically on demand, which is not exactly what is mainstream Islamic law. The rules of inheritance also are almost unrecognizable. They grant much more rights to women in inheritance that you would expect from Islamic law, and even find ways of giving inheritance to people who have abandoned Islam, who converted to Christianity, for example, which is also not mainstream Islam. Polygamy is very limited. needing the consent of the wives, which is quite common in many jurisdictions that apply Islamic law, but it's very, very limited. And child marriage is prohibited by law. So I can see that many Westerners would say, well, this is the kind of Islamic law that I would like, right? But the issue then becomes, is it a credible Islamic law? Is the state credible in applying or trying to influence Islamic law? And if the state controls Islamic law in this way, is that leading to more fundamentalist movements? People who say this is not Islamic law. This doesn't respect the Sunnah. This doesn't respect the Quran. And therefore, I want my own little system. It's particularly difficult in a country like Singapore, where the majority is not Muslim. Indonesia, as you know, is the largest Muslim country in the world, Muslim majority country in the world, the fourth largest country in the world in terms of population. But in Singapore, the government controls the court, appoints them, and the government is elected by a majority of non-Muslim. Or in France, you have the Conseil français du culte musulman. What is the government of France trying to do in influencing Islam? What credibility will it have? In fact, something really interesting happened in Indonesia in 2002. Let me explain what happened. There was a movement in two attempts in 1945 and 1959 to include a mention of Islam, that Muslim must follow Sharia in the constitution of Indonesia. And that was rejected in both instances in 1945 and 59 for political reason. In 2002, there was an attempt by a small group to introduce in the constitution yet again the words that Muslim had to follow Islam. First mention of Islam in the constitution, which is not mentioned in the secular constitution. And the two largest Muslim organizations in Indonesia have rejected the introduction of Islam in the constitution. Let me repeat this. Two Muslim organizations representing over 100 million Muslims rejected the introduction of Islam in the Indonesian constitution. Why? Because in part, there are many reasons, but in part, because they didn't want the state to decide which version of Islam should be applied. In Sunni Islam, there are like 4 main schools of Islamic law, and that's only Sunni Islam. And therefore, there's different Islamic law. There's legal pluralism inside Islam. And they didn't want that to be taken over. So they thought, we have the courts, we have family law already controlled by the state. We don't want the state to regulate Islam more than that. So it's interesting to see that. Now, also, so they want Islamic law unofficially, not applied officially by the state. We also have increasingly Adat law, which is a resurgence of unofficial Adat law. People are just gathering and saying, we're going to decide the case. Let's forget about the court of the state, especially since they're very corrupt, right? Let's do it ourselves according to our own traditional law. So there's a resurgence of these kinds of things. But basically, we are still talking of the relationship of customary law and religious law with the state. As M.B. Hooker, who wrote on legal pluralism, used to say, the customary law and the religious law are still considered subservient. It is the state that kind of determines whether we recognize them or not, whether we leave space for them, and otherwise they're unofficial and the state kind of ignores them. So we still have a very much a Westphalian concept of the state, which determines the sources of law, including sources of customary law and sources of Islamic law in the case of Indonesia. So I think this is unusual for most Western countries to have this level of official legal pluralism, and the difficulty that we face in Indonesia and Singapore and many countries in Asia and Africa to have this kind of pluralism. So hopefully that will provoke some debate. And thank you very much for your attention.
Thank you very much, Gary, for those insights and also for just bringing a very nice fit to also the theme of the conference, where comparative analysis between countries like Singapore as well as Indonesia where you are currently based. But also following up from the presentation of Krista, you could find the links from the South African jurisprudence in terms of African customary law, as well as issues, loss of religion, among others. So thank you for that. And there's hope indeed for collaborations as well as comparative analysis from the 3 jurisdictions in that regard. Ladies and gentlemen, I see on the monitor that we do not have questions, but please feel free to join the debate as per the initial invitation from the 2 panelists which we are hosting this evening or afternoon in the context of South Africa. But without further ado, the participants also have a few startup questions to just stimulate as well as to appetize your palates with regards to this debate. I will then shoot straight with regards to the pluralistic state. And the first question deals with, are pluralistic states truly pluralistic, or have the state taken control and legislated religious and customary laws to fit into the state's objectives? Christos, your views there?
It was actually meant for the audience to give their views on the different jurisdictions, but I'll start by giving my viewpoint. We are now at the Law Reform Commission, for example, busy doing an investigation into the possibility of a single marriage statute. And some of the debates at that in the commission is, for example, should the state be involved in each and every religious and cultural practice of families? In a marriage, for example, should the state be involved in how you must celebrate your marriage? Or is there a minimum core of requirements that the state should be involved, such as parties must be 18 years and older, they must give consent, and they must have the capacity to get married? Should the state prescribe to you where, how, which religious, what are the religious rules? What should the ceremonies be? Should the state be involved in those actions of the different religious and cultural groups? And I think it boils down to that. Is there a point where the state should not legislate, especially in a private sphere of marriages in this example? And my feeling is no. And what was interesting is that many religious groups wanted what they call omnibus legislation, where you have an act that has the secular rules that I just mentioned, but then there must be different doors going to all the different groups, such as Christianity, Muslim, Islam, Jews, and those different doors must then be separate acts added to this one, explaining exactly the rules of that particular religion. But then it comes back to Gary's problem of how much involvement should there be from the state? The moment you put, and all the differences, that pluralities within a religion, how do you put that in a piece of legislation? How do you get everybody to agree? And then you fix those rules in that act, and then you also hamper modernity and the evolvement of that legislation, because you want everybody to do it like this for the next 300 years. I have a problem with too much state involvement in plurality, I think.
Gary, your insights, but before your insight, can I maybe request the production team to please put the questions on the monitor to enable members of the audience in the auditorium, as well as members of the audience online, to have access to them in order to engage with the panel this afternoon. Thank you. Gary, your views?
Well, I mean, it's of course, it's not for me to decide what Indonesia should do in terms of how much they should intervene. But let me give you an example of intervention. For development purposes, the government of Indonesia had decided that they had to control the population. People were having too many children. We're talking from the 60s. And one of the things they did was limit the children to two, what they call the keluarga baru, the new family, mom, dad, and 2 kids. And that excludes polygamy, right? So they took all kinds of measures, both in terms of applying Islamic law to put more requirements, proving that you have enough money for a second wife, getting the consent of the first wife, and all kinds of requirements. Also, other measures that are outside of Islamic law. If you are polygamous, you lose your government job. So everyone who is polygamous cannot have a government job. So they did all kinds of things that went against one of the things that is allowed in Islam. And is that correct? Is that, well, I certainly think they influenced Islam quite a bit by doing that. But that was a decision that the state took for state reasons, right? The problem I have is when they start regulating the inside of Islam, rather than let the Islamic scholars interpret Islam, which is the traditional way in which Islam is developed over time. Islam should be developing. They fix it into the Compilasi Hukum Islam, which is a very simple book, which doesn't really gives a good idea of the treasure that Islamic law can be. But I'll leave it at that.
Thank you very much, Gary. From what I gather from the presentation of Gary as well as Krista is customary law is still underdeveloped, considered inferior, among other things. Then my question would be, would language, for example, in indigenous language, play an important factor, among other things, to start the development of African customary law? For example, let's talk about the Bear case, which you might be very familiar with, where the issue in dispute was not a check, and it was a matter of distortion when you read the minority judgment that they spoke about the issue of patriarchy, among other things. Would maybe penning that judgment in an indigenous language, which was very clear and confident to the participant, not play an important role in developing the jurisprudence of customary law?
It's a difficult question, Charles. Remember, courts, judges, not all of them have expertise in all the African languages, so they depend on interpreters in court, and they depend on the evidence put before them. Sometimes I think we expect too much from judges, especially from the South African judges, because, I mean, how a case works in South Africa is that parties that wants to litigate take the case to court and they put the evidence before court. So we expect courts to do so much more than they are enabled to do. Whether language would help would then, I think my short answer is it would depend on what the parties put before the court. So it's their responsibility to make sure that they put the correct language before the court and make sure that their papers are correct. So it would not so much depend on which languages the court can speak, or the interpreter for that matter that interprets in court, but what the parties take to the court. And it must start there with the counsel of the different litigators.
Thank you. Gary, your views on the importance of language in the development of indigenous or customary laws, among others, as well as religious practices?
Yeah, well, Indonesia has some 300 languages. So it really is an extremely diverse country in terms of languages. But of course, about close to 50% speak Javanese, which is one of the main languages. But the Dutch have ossified customary law, and they have written in Dutch and saying the people of this group have this law and the people of that group have this law. That's what is still being applied in court today. So it's not a very living customary law. It's a kind of a coded, well, it's not a code, it's from jurisprudence, but it's kind of a written customary law, which is a contradiction in terms of, obviously. But we have a detail, like for example, for inheritance, we have detailed rules for Balinese, for other people as well, of how their inheritance law would work. And of course, for anthropologists, etc., who are trying to find a real unofficial customary law, that's quite important. The problem, not a problem, I shouldn't say problem, but there's been a big change. I told you earlier that the Dutch preferred Adat law to Islamic law. So many things were regulated by Adat. There's been a change recently, and now for all Muslim, Islamic law of inheritance prevails over Adat. So there will be less Adat now because 87% of Indonesians are Muslim. So they will be governed by Muslim law. So the customary law will have a lesser role in inheritance and family matters.
Gary, there's a question from the members of the audience. I think this one, Krista, who's very well acquainted with the South African jurisprudence, can be able to tackle it. It reads, if state courts in South Africa apply common law rules to Muslim people, e.g. inheritance rights for spouses, although they did not conclude a civil marriage, does this not lead to a less legal pluralism instead of an increase of legal pluralism? Krista?
Thank you. Yes, that is the whole debate. It's one of the reasons why Muslims, for example, do not conclude a marriage in terms of the Marriage Act. The South African Marriage Act is, at this moment, though it was not initially, secular in nature. So it does not prescribe any religious rules when you conclude a marriage. But the thing is, the moment you conclude a marriage in terms of South African Marriage Act, then South African law applies to your relationship. So divorce, maintenance, custody, succession, all those typically common law acts will then apply to your relationship. And that is the biggest problem that Muslims have in South Africa, is that they don't want South African law to apply to their relationship, but Muslim law. And that is one of the reasons why they don't marry in terms of that act, though that act do make provision for Muslims to register their marriage in terms of that act, even if they did not, even if they concluded a Muslim marriage. So with regard to celebration then of diversity and plurality, when courts apply South African common law to that relationship, perhaps one can argue it is less recognition of plurality, but you can also make the argument, the fact that the court recognizes that relationship and gives protection to the parties in terms of legislation that does not really apply to those relationships. Maybe that is also a form of legal plurality, because they do recognize that there are other situations in South Africa where parties need protection. And in most cases, it's the women in those relationships that needs the protection. So I think you can put the argument different ways, because if it was, the court did not recognize that plurality in the South African society, it would just have said, well, they are not married in terms of South African laws, so I'm not going to recognize this relationship, and there are no consequences attached to it. Yes, I know it's probably not the answer the person asked for, but that is my feeling. The courts are in a catch-22 situation. There is no legislation that applies directly to those relationships. What do? They develop the South African laws to make provision that also includes those relationships to give protection to the parties.
Okay. Thank you very much, Christoph, for that. Gary, maybe to just ask this last question from my side before you give your closing remarks, and also maybe Krista can be able to engage a little bit on this point. Is the consensual nature of customary law as well as religious laws not one of the main factors that put them at the back foot of them being so underdeveloped, among other things? Because when you look at customary law, it cuts across the entire spectrum of law. When you speak of law of contract, criminal law, you name that, customary law is able to field into, but we have decided to box it into one system that not regulates only matters of private law, but it doesn't extend just like common law, among other things. And yet that was not the case, for example, in the South African context, when colonizers arrived in the South African context, customary law was the one that was dominating, but we tend to box it, even though it is recognized currently by the Constitution, but it's still boxed to affairs of private law, but does not extend or cut across. So my question in a nutshell is the consensual nature of it. Is it not one of the main stumbling blocks towards its development in the 21st century?
Well, the boxing of it, to use your expression, is really a colonial legacy, right? And I can't see, there has been debates in Indonesia, whether and the debate is not toward more customary law, but whether there shouldn't be more Islamic law. And part of the reason why people say that we should be more Islamic law is because the Islamic courts, which are separate from the other courts, I mean, at the top, they're the same, but the Islamic courts are not corrupt, are perceived as much more honest and less corrupt. So people say, why don't we go to these courts and have more things in these courts? But we're still in a box system. And there was debate, however, in this one region in Indonesia, Aceh, which was allowed for political reasons. They wanted separation. They get a deal in which they have more Islamic law. They are allowed to apply more Islamic law than the rest of Indonesia, including some aspects that are quasi-criminal, including, you know, caning in some instances, flagellation basically. So, but there's no, what is happening is small communities are basically unboxing themselves by actually just ignoring the state court and state law and deciding things amongst themselves. So you see that very much in family matters even. People just go to the village head, try to solve their matters. And if everyone agrees, then it never goes to court. But as soon as someone agrees, if they're Muslim, they go to Islamic court. If they're civil, as soon as someone disagrees, they go to either religious Islamic court or civil courts, because anyone who doesn't consent to the application of this community law is entitled to go to the courts of the state.
Gary, Christoph?
Thank you. I think the stumbling block for the development for customary law is now the fact that it is a living law and that it is plural in nature as well. So customary law is an umbrella term for all the different customs of the various traditional communities in South Africa. So when we speak about customary law and you say, should we not develop customary law more, it makes it difficult because whose community, it's the same with the plurality in Islamic law, which community's customary law are you going to accept as the norm? And if you accept only one, it's going to mean you favor one traditional law over the other. So it will be difficult, extremely difficult to say we're going to develop customary law. I mean, it is a problem. Common law and even the Roman Dutch law and even English law is also sort of based on custom, but because all the attention over the years were on those laws because of the powers of the colonialists, they developed uniformly into a certain direction, but it's not going to be that easy with customary law. And the moment that you develop it, you fix it as well, and then somebody is going to court and saying, well, the customs of our community is different of what you are saying customary law is. And then we get back to that whole ossification and fixed arguments that we've been having over the years. That is what the South African government has been doing with all the national legislation, is trying to say we have something uniformly for customary law, and it is not uniform. So it is difficult, and I suppose we are going to have many years of debates on this over the years. The moment you write it down, you fix it, and then people saying, well, now it's not living law anymore, and it's fixed, and that is not what customary law is.
Thank you very much, Krista. Gary, your closing remarks, please.
Well, I think it is a challenge, but it's also an exciting challenge. I think it's a very it's a more interesting way of thinking of law. It's linked to culture, it's linked to communities, and it's an interesting way. And the constitution can play a role. And I will finish with that, something I have not mentioned. The Indonesian constitution does mention adat law in it, but nobody had any, I mean, there was no case, there was nothing. And I said, I think this could be used by some communities to reinstate their rights. And actually, the Supreme Court actually decided, the Constitutional Court, sorry, decided that the government of Indonesia, their state land, had to respect indigenous law, which was a surprise to everyone. They just used a provision of the Constitution that had been there since 1945 and that nobody have used before. So you can see that there is an increasing place for, and people want to have laws that are customary. And it'll be interesting to see the development over the years.
Krista, closing remarks, please.
I thought that was my closing remarks.
Oh. Say bye to the audience.
Shall I just say I concur?
Yes. Ladies and gentlemen, the auditorium and those who are joining us live stream, thank you very much for joining us in this engaging and thought-provoking presentation from Professor Christa Ruttenbach from the University of Northwest in South Africa, as well as from Gary, who's also a professor in Singapore, but currently based in Indonesia. Thank you very much. Ladies and gentlemen, it was a long marathon today at the University of Pretoria, and would like to wish you well, good health. We still live under COVID-19 conditions. Please stay safe and have a wonderful evening. To those whose morning, we wish you good morning. Reperele, cheers, and we convene tomorrow. Thank you. Bye for now.